Good afternoon, everyone. Thank you for joining us today for our virtual meeting of the DNC's Credentials Committee. As a reminder, this is an official meeting of the committee. We are live streaming these proceedings on the DNC's YouTube channel, and these proceedings are also being transcribed by our court reporter for our official record. I hereby call this meeting of the Credentials Committee to order. Thank you all for joining us today. My name is Ryan Ramirez, co-chair of the Credentials Committee. I'm coming to you from the ancestral homelands of the Suquamish tribe here on the Port Madison Indian Reservation. And I am also joined by my co-chair, Supervisor Hilda Solis. Supervisor?
Yes, thank you, Ryan. I'm here in beautiful Los Angeles, where it is a good 76 degrees, not 98 like it was over the weekend. I want to thank everybody for joining us. And I will ask you, please, if you'll join me in reciting the Pledge of Allegiance. Please place your right hand over your heart and repeat after me. And you can stand if you'd like. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Thank you. Back to you.
Call the roll. When Helen calls your name, the production team will unmute your microphone and you may respond to the roll. Helen?
Need to be unmuted. Thank you. Mr. Aguilar? We'll come back to him. Mr. Buckley?
Here.
Thank you. Ms. Davis?
Here.
Thank you. Mr. Degnan? We'll come back. Ms. Hernandez-Matz? Mr. Jacobs? Thank you. I can see you and you're unmuted. Mr. Knapp? I'm sorry, Cap?
I'm here. Thank you.
Thank you. Mr. Lee has given his proxy to Ms. Pelosi.
Present for Supervisor Lee, who's at budgetary hearings today for his county.
Ms. Leong Hong.
Here.
Ms. Lucas.
Present.
Mr. Mallory.
Present.
Ms. Maxwell. Ms. McBride. Mr. Middleton.
Here.
Mr. Newman. Ms. Pelosi. I see you.
Present.
Ms. Penske has given her proxy to Ms. Lucas.
Yes, present for Ms. Penske.
Ms. Pringle. Ms. Rollins.
Present.
Ms. Ruiz has given her proxy to Ms. Davis. Mr. Valdez.
Present.
Mr. Walters.
Present.
And I will go back. Mr. Aguilar.
Present.
Mr. Dignan. Ms. Hernandez-Matz. Ms. Maxwell. Ms. McBride. Mr. Newman. Ms. Pringle. You have 18 people present in person or by proxy, Mr. Chair, or Ms. Chair.
Thank you, Helen. We have a quorum per our charter and bylaws. A quorum is constituted by 40% or 10 credential committee members present in person or by proxy. Before we get underway, I wanted to recognize the team who supports the committee. In addition to Helen, we are joined by the Office of the Secretary and Party Affairs and the DNC Counsel, Andy Levine. I'd also like to thank the technical support team, Weymouth, Watson. Thank you, everyone, for helping to make sure our meeting runs smoothly. As we move into the business of the meeting, please keep in mind that members will be muted until they are recognized to speak, at which point they will be introduced and unmuted by the production team. If a member would like to be recognized for comments or questions, please use the raised hand function in the Zoom, send a chat to DNC support, or send a chat to DNC support. When you raise your hand or send your chat to DNC support, we will create a queue of pending questions. When it is your turn to speak, you will be announced and unmuted. As we begin, we'd like to thank Chair Martin for live streaming these proceedings. This is a practice that the chair has committed will be the standard for all standing committee meetings moving forward, both in person and virtual, which is really important, guarantee for transparency and accessibility for the party. For those at home who are observing this committee's proceedings for the first time today, I'd like to take a few minutes to walk you through the role of the Credentials Committee. The Credentials Committee is composed of 24 members of the DNC, Democrats from across the United States, who were appointed by Chair Harris and confirmed to their positions by the entire DNC membership. This committee is governed by the DNC bylaws and the committee's rules of procedure, which were adopted by the full committee in 2021. Our bylaws require that the Credentials Committee receive and consider all challenges to the credentials and seating of DNC members. All parties must be granted a reasonable opportunity to be heard, and once the committee has reviewed the party's evidence and arguments in accordance with the rules of procedure, it adopts a recommendation for the resolution of the challenge for the full DNC's consideration. Ultimately, our responsibility is to review the specific allegations in the challenge and the challenged parties' responses and determine whether the challenge should be granted or denied. This committee takes seriously our responsibility to navigate the complex issues raised in credentials challenges and make just and well-reasoned recommendations to our 400+ colleagues. This fact that we are hearing today's challenge, which considers the process executed by the DNC itself, demonstrates what's unique about the Democratic Party. As Democrats, we believe in transparency, and as the chair has said and shown, that one of his top priorities is democratizing the DNC. I know it goes without saying to you, but I'd also like to assure the parties participating and viewers at home, all members here will weigh the evidence and arguments and determine a resolution that reflects the values of our party. As codified in our charter, bylaws, and other rules, our deliberations and votes will be public, and we'll do our best to make sure that our reason is clear to all viewers. Before we move to the challenge, do any members have any questions? If so, please raise your hand via Zoom. Not hearing any or seeing any. Seeing no further questions, we'll move to new business. Hilda?
Yes, thank you. Today we'll consider a challenge filed by Kaylin Free regarding the seating of Vice Chair David Hogg and Vice President Malcolm Kenyatta. As we hear and consider the challenge, I'd like to echo my co-chair's sentiments. I've been incredibly proud to work with this committee as we reviewed, considered, and passionately debated credentials challenges these last 3.5 years. The issues in these challenges are rarely clean cut, and that's why they make it all the way up to us. We then have a responsibility to parse the complexity during our public hearings and determine what resolution best reflects the facts and our values. Whatever the determination of the committee today, the DNC is prepared to ensure that all DNC members have a say in the ultimate result and then to execute on the solution we recommend. To talk about the immediate next steps, DNC General Counsel Andy Levine, will provide an overview of the hearing process as provided by the rules. Andy.
Thank you, Chair. Parties and members of the committee. The DNC's bylaws vest this committee with the authority to determine the validity of the credentials of those elected to the DNC. As a committee, it is your responsibility to review the allegations in the challenge and the evidence and arguments presented by both sides, and based on the evidence, determine whether to recommend that the DNC grant or deny the challenge. You will likely hear presentations from both sides on the scope of the challenge, the facts at issue, whether violations occurred, and what proposed remedies should be. Ultimately, you must weigh the evidence and arguments as a committee and come to a determination on what your recommendation to the DNC will be. The Credentials Committee's rules of procedure govern the conduct of committee business. The rules provide that they should be interpreted so as to promote the fair, expedient, and efficient conduct of the committee. The committee's rules provide that the co-chairs may schedule an open and public hearing on the specific factual and legal matters in dispute. The hearing may be conducted by a hearing officer or by the Credentials Committee itself. When hearings are conducted by the committee, the co-chairs and the committee assume all authority granted to a hearing officer by the committee's rules. As such, this committee has all power necessary to conduct a hearing in such a manner so as to secure the just, speedy, and inexpensive determination of the challenge. Additionally, the co-chairs may take such actions as may be necessary to carry out the committee's rules or to facilitate the effective operation of the committee. The committee has the authority to receive all competent evidence relevant to the specific matters at issue and to assign the appropriate weight to such evidence. As such, the co-chairs have provided the parties with the opportunity to submit documentary evidence to this committee for its consideration. This material was distributed to each member last week. The co-chairs also informed the parties that each side, proponents of the challenge and opponents of the challenge, have been allotted 30 minutes each to present oral testimony and argument for the committee's consideration. The challenging party is allowed to reserve 5 minutes for rebuttal. The co-chairs have not narrowed the issues that may be raised during these presentations so that the full committee can determine which evidence and arguments are relevant to their consideration of the challenge. Please keep in mind that since only members of the committee may propose motions, the committee will not grant or deny dispositive procedural requests during the parties' presentations. Rather, if either party requests committee action that could dispose of the challenge or substantively affect the results of the challenge, such action will only be debated and considered if a motion is made by a member of the committee after both presentations have been completed. To that end, please hold all questions and comments until after both presentations have been completed. After the parties have made their presentations, the committee may engage in up to 30 minutes of discussion and debate, during which time members may address questions to either a party's counsel or representative. Their counsel or representative may invite their client or a witness presented by the client to help answer the member's question. Following debate, the co-chairs will recognize a committee member for the purpose of offering a resolution disposing of the challenge, which may be debated for up to 20 minutes, split evenly between proponents and opponents. At the conclusion of the debate, the resolution will be put to a vote. A majority vote is required to adopt a resolution disposing of the challenge. In the event the first proposed resolution is not adopted, the co-chairs will continue to recognize committee members for the purpose of offering resolutions disposing of the challenge until the challenge is disposed of. The resolution will then be compiled into a written report, which will be referred to the full DNC membership for its approval. Thank you in advance for your work today.
Thank you, Andy. The challenging parties, including the intervening party, will be recognized to present their case first. You will have 30 minutes measured by a time clock available for all Zoom participants to view. Please be sure to introduce yourself for the court reporter and specifically indicate your reference exhibits by number. The production team will unmute presenters. The order in which they have been instructed to do so by counsel is Susan Enroll, challenging party counsel, Dr. Daniel Siebold, witness, Susan Enroll, challenging party counsel, Lauren Phillips, intervening party counsel, Susan Enroll, challenging party counsel, and Christy Holland, witness. The challenging parties are now recognized. The challenging party is represented by Susan Enroll. Please indicate verbally when each witness should be called. Ms. Roll, you are now unmuted. The 30-minute timer will begin now. You will be able to reserve up to 5 minutes for rebuttal. It is your responsibility to watch the clock and indicate that you will be using the remaining time up to the 5 minutes for rebuttal. Thank you very much.
Thank you, Mr. Chairman. Distinguished committee co-chairs, committee members, Representative Kenyatta, Mr. Hogg, counsel, Madam Parliamentarian, and members of the DNC staff. My name is Susan Eads Roll, and my client is the challenging party, Kaylin Free. Ms. Free brought the challenge to the seating of Malcolm Kenyatta and David Hogg as DNC vice chairs, the matter which is before you today. During the challenging party's allotted time, you will hear 1, the undisputed facts of this challenge, 2, expert testimony from Dr. Daniel E. Siebold, chair of Hofstra University's Department of Mathematics and an author of the current and 11th editions of Robert's Rules of Order newly revised, the parliamentary authority named in the DNC charter. A statement from the intervening party's counsel, Laurie Phillips, and the proper steps to take under the rules adopted by the DNC to resolve this challenge. The pertinent facts are as follows. On February 1st, 2025, following the election of other DNC officers, balloting for the vice chairs was conducted. Chairman Ken Martin was not present during the election of any of the officers, and after being elected, he took the reins and immediately went to work, taking the Democratic message to the country. On the first of these ballots for the office of Vice Chair for Civic Engagement and Voter Participation, Raina Walters Morgan received a majority of the votes cast and was elected. On the second ballot to elect the first of the at-large vice chairs, Artie Blanco received a majority of the votes cast and was elected. With the election of Mrs. Walters, Morgan, and Blanco under the DNC's rules, the election of a male vice chair was necessary in order to achieve gender balance among certain elected DNC officers. On the subsequent third ballot, on which there were 5 remaining candidates, 2 men and 3 women, the voters were instructed by the presiding officer to vote for 2 candidates, one of whom had to be male, on a single ballot. The votes on these questions were then tallied together. The announced results of that ballot were on 411 ballots total cast that Malcolm Kenyatta received 298 votes, David Hogg received 214.5 votes, Gina Repass received 112 votes, Kaylin Free received 96 votes, and Shasti Conrad received 91.5 votes. Representative Kenyatta and Mr. Hogg were declared elected to the 2 remaining vice chair positions. On February 28, 2025, Kaylin Free submitted her challenge to the seating of Representative Kenyatta and Mr. Hogg as vice chairs. Next, I call Daniel Siebold, PhD, professional registered parliamentarian, as a witness for the challenging party. Professor Siebold, please state your academic and parliamentary credentials.
I hold a PhD in mathematics from the University of California at Berkeley. Since 2008, I've been a member of the authorship team of Robert's Rules of Order newly revised. I'm also credentialed as a professional registered parliamentarian by the National Association of Parliamentarians.
Please describe your experience in the field of parliamentary law and procedure.
In addition to participating in the writing of the most recent 2 editions of Robert's Rules of Order newly revised, I've served as parliamentarian for a number of professional, academic, and homeowners associations. I regularly speak on parliamentary topics to national audiences.
What were you asked to do when you were retained by Ms. Free?
I was asked to analyze the conduct of the ballot elections for the DNC at-large vice chair positions at the February meeting under the rules contained in Robert's Rules of Order newly revised and the DNC's own custom provisions contained in the charter and other procedures. I was asked to write an opinion stating the result of that analysis and to testify about it before this committee.
Ms. Free or I or anyone else tell you what the findings in your report should be?
No.
Your analysis of the third ballot procedures is located on pages 3 through 5 of your report, which is Challenging Parties Exhibit Number 1. Please state your findings.
So during the third ballot, the members were asked to cast votes for two candidates, one for each of the two at-large seats. There were two vice chair positions still vacant at that time. It's actually pretty common when voting to fill multiple identical seats from a common pool of candidates to vote in this way. Each member casts as many votes as there are open seats. All the votes are titled, and those candidates who receive the most votes are elected, provided they have a majority. What jumped out at me about the third ballot, however, is that in this case, the two seats had different lists of eligible candidates. The voters were thus being asked to vote on two entirely different questions at the same time. Which of these two male candidates do you prefer? And which candidate should fill the seat that can be filled by a candidate of any gender? And the votes on those questions were then counted together. Because each male candidate was eligible for both seats, they were able to receive votes on either of the two questions. A vote expressing a preference for one male candidate over the other, and a vote expressing a preference for that same male candidate over all others for the any gender seat were treated as if they were the same thing. But they aren't. And the votes on these two questions should have been counted separately.
In your report on pages 5 through 6, again, Challenging Parties Exhibit Number 1, you analyze the advantage conferred on the male candidates over the female candidates and how this advantage violated provisions of the DNC charter. Please describe these points.
Sure. So the DNC essentially set before the candidates two baskets, each containing about 400 votes. It then told the male candidates that they could share the contents of the first basket between themselves, and that they and the women would share the second basket. This procedure certainly ensured that the male who received the larger share of the first basket would have a majority that he needed for election, and that was what was intended. But it also gave the less preferred male candidate a large and potentially insurmountable lead over the female candidates. So what I'd ask you to do is just assume for simplicity that there were 400 ballots in each basket to make the computation simple. And suppose that the ballots in that first basket being split between the two men ended up being split with 250 for candidate A and 150 for candidate B. Candidate A would then be elected as the more preferred male candidate. Then, from the second basket of 400 ballots, candidate B would only need an additional 51 votes to achieve a majority of 201. But a female candidate would need 201 votes out of that basket. The male candidate thus had an enormous head start on reaching 201, so that a female candidate would have had to substantially outperform a man to have the same chance at election. I went a little further in my written opinion and pointed out that in the circumstances I'm describing, where the first basket is split 250 to 150, if the 400 votes for the all-gender seat had simply been cast at random by rolling dice, candidate B in this scenario would have had a 96% chance of being elected by pure luck. So in attempting to guarantee that at least one male candidate was elected, the DNC used procedures that all but guaranteed that both male candidates would be elected.
Just to underscore the points that you just made, what was the effect of the third ballot's balloting procedures on the available votes for the two men versus the available votes for the three women?
So each of the candidates was competing to be listed on a majority of ballots, which is a little over 200 ballots. But each man was effectively gathering votes from an available set of 800 votes, while each woman was gathering votes from a set of 400.
You also analyze on pages 6 through 8 of your report, again, Exhibit 1 of the challenging party, the grounds for challenging a result after adjournment of a meeting. Please describe the points of your analysis, including the significance of a breach of a continuing nature.
Okay, so Robert's Rules of Order newly revised generally requires that if a point of order is raised, then it must be raised at the time the breach occurs. So, for example, you can't raise a point of order that a motion was improperly adopted at the last meeting because that motion was never seconded. It's too late to raise that point. But there are exceptions to this rule. Certain improper acts are considered so severe that they result in what are called continuing breaches, so that the action taken is null and void. And in these cases, an objection can be raised at a later time. Examples include when action has been taken in violation of what's called a fundamental principle of parliamentary law, and when action has been taken in violation of a rule protecting a basic right of an individual member. The procedures used to conduct these elections gave rise to 3 continuing breaches. First, it's a fundamental principle that only one question can be pending at a time. By counting the votes on 2 different questions, which male candidate should fill the male-only seat and which candidate should fill the all-gender seat, the DNC violated this principle. Second, if a majority of voters preferred candidate A to candidate B among the 2 men, then the votes cast for candidate B could still be counted in his contest for the other seat. For this reason, voters who voted for candidate B were effectively granted 2 votes for the all-gender seat in violation of the fundamental principle of parliamentary law that each member of a deliberative assembly is entitled to one and only one vote on a question. These extra votes resulting from this violation were essential to the outcome. In choosing among the 5 candidates for the all-gender seat, over 70% of the voters voted for female candidates. So there simply weren't enough votes remaining to allow either male candidate to get a majority for this seat, except by counting the votes they had received for the male-only seat. The third issue is that each member of the DNC has what we call a basic right. That's like a parliamentary term of art, a basic right to vote on each question that's taken up. So I want you to consider the case of a voter who prefers candidate B over candidate A among the 2 male candidates, but who also believes strongly that the open seat, the seat that's open to candidates of all genders, should be held by a woman. So this voter marks a ballot with 2 names, candidate B, the preferred of the male candidates, and Kaylin Free. But that vote for candidate B, although it expresses only the voter's preference for B over A, may then also be used to elect candidate B over Free to the seat open to candidates to all genders. So by merging the votes on these 2 questions, the DNC effectively deprived this member of the basic right to vote on the question, who do you prefer among Conrad, Free, Hogg, I think Kenyatta, and Repass? So, the talk of fundamental principles and basic rights in these 3 cases all reflect one very basic problem. And that is that the DNC combined the votes on 2 separate questions in a way that prevents us from determining the will of the majority on either of the 2 questions. Under Robert's Rules of Order newly revised, these procedures result in a continuing breach so that it's not too late to raise an objection to the validity of the elections.
Do the intervening parties, who are 7 members of the DNC, share the same interest in the violation of the DNC's rules, the charter, the fundamental principles of parliamentary law, and the basic right to vote that you've just gone over?
Yeah,
resulting from the third balloting procedures, and if so, why?
Yeah, sure. As members of the DNC, I think they do share the same interest. The issue here isn't simply the rights of 3 female candidates who were treated unfairly. These procedural breaches, violations of the fundamental principles of parliamentary law and of members' basic right to vote, render the elections null and void. Any member has a right to raise an objection to the actions that were taken.
Challenge Party Hogg argues Rule 2C5 of the 2025 Rules of Procedure for the election of DNC officers means that whether or not voting was conducted one at a time among a gender or all together was a matter left to the discretion of the chair. Is his interpretation of the rule consistent with applicable DNC rules, including the charter, fundamental principles of parliamentary law, and basic rights of individual members?
Yeah, I mean, I think Mr. Hogg is correct that the DNC proposed 2025 rules of procedure do state that it's at the discretion of the chair that voting for each of the vice chairman positions can be conducted, one at a time among candidates of the appropriate gender. But if the chair does not exercise her discretion to conduct the votes for each position one at a time, she's still obligated to conduct the voting properly and not to violate any fundamental principles. Now, I suggested when I wrote the opinion that the voting be conducted separately for the two positions, mainly for simplicity. But if the chair elected to conduct them on the same ballot, it can be done properly, but not in the way that the DNC did it. What you would do is you would have each voter instructed to vote for any two candidates with no restriction. And the tellers would then count the number of votes each candidate received on all ballots. If the candidate who had the highest number of votes received a majority, the chair would then declare that individual elected, whether the candidate was male or female, because you can elect a male and you can elect a female. Then you would go to the next person on the list of candidates by order of the number of votes they received. And if that person also received a majority, before declaring that person elected, the chair would have to pause and ask a question. And that is, was one of the top two candidates male? If so, then there's no reason not to go ahead and declare that second candidate elected. You've met the gender parity rules. However, if the top two voter getters are female, then in that case, the chair should announce that the charter's rules on gender parity would be breached if that second person were declared elected. So there's no election for the second seat, much as if the second person hadn't received a majority. In that case, the DNC would need to ballot again, and that ballot would be restricted to the male candidates. So it can be done. You can attempt to collect this on a single ballot, but it has to be the same question that's being posed to all the voters. Which two candidates do you prefer?
Challenge party Kenyatta asserted that overturning certified elections and holding new races with a different candidate pool, a different process for voting, and a different electorate would violate the DNC's charter and bylaws and disenfranchise members whose votes have already been counted. Do you share this opinion?
I do not. I mean, the unfortunate circumstances here are simply that the DNC thought it had properly completed the election of the vice chair positions, and it has not. Leaving in place decisions that were improperly arrived at effectively disenfranchises all members. Declaring the elections null and void and completing them properly, including ensuring that the gender parity rules are met, is the correct procedure. It is absolutely true that if these elections are conducted again, it will be those individuals who are members of the DNC at the time the elections are completed who will be entitled to vote. They will be the ones who will be acting on behalf of the DNC.
Your report on page 8, again, exhibit 1 of the challenging party, you state how to properly cure or resolve the violations of the DNC's rules resulting from the third ballot's balloting procedures. Would you please again highlight those steps the DNC should take?
Yeah, yes. If the DNC determines that the announced result of an at-large vice chair election is null and void, then the parliamentary term we use here is that the election is considered, quote, incomplete. And the rule is that it should be completed as soon as practicable at a meeting of the DNC under procedures that guarantee the DNC's gender parity requirements are met, following any other rules of the DNC. If there are two elections that have to be run and they have different lists of candidates, then the votes in those two elections should be counted separately. The threshold for election is a majority of the votes cast in an election.
Thank you very much, Dr. Siebold. Next, Lori Phillips, counsel for the intervening parties, will provide a statement on behalf of those parties.
As Dr. Siebold testified, the intervening parties who are members of the DNC share the same interest as the challenging party, Kaylin Free, in the violations of the DNC's rules. The issue here is not simply the rights of 3 female candidates who were treated unfairly. These procedural breaches, violations of the fundamental principles of parliamentary law and members' basic right to vote, render the elections null and void, and any member has a right to raise an objection to the actions taken. After the members were forced to cast 1 vote for a man, on the last ballot, the members were then allowed to vote for a candidate of any gender. It is significant that when the members have the opportunity to vote for any of the 2 men or 3 women candidates, the members overwhelmingly express their preference for a woman candidate by 72.77%, with 302 out of 415 members casting their vote for a woman. The intervening parties stand in complete agreement with Dr. Siebold's report and testimony and request the same relief as the challenger. 2 new elections for the last 2 vice chair positions, 1 male, the other all genders. I will not call any witnesses.
Thank you, Attorney Phillips. In summary, at its February 1st, 2025 meeting, the DNC mistakenly treated 2 separate questions. Who do you prefer between Hogg and Kenyatta? And who do you prefer among Conrad, Free, Hogg, Kenyatta, and Repass, as though they were the same question, and tallied the votes on these questions together? The adoption and use of procedures that conferred an overwhelming advantage to male candidates over female candidates clearly violates 2 provisions of the DNC charter, namely Article 1, Section 4, the DNC shall establish standards and rules of procedure to afford all members of the Democratic Party full, timely, and equal opportunities to participate in the decisions concerning the selection of candidates, the formulation of policy, and the conduct of other party affairs without prejudice on the basis of sex. And Article 8, Section 2, which states discrimination in the conduct of Democratic Party affairs on the basis of sex is prohibited, to the end that the Democratic Party at all levels be an open party. Additionally, these procedures violated the fundamental principles of parliamentary law, that only 1 question can be considered at a time, and each member is entitled to 1 and only 1 vote on a question. These procedures also violated the basic right of individual members to express their preference to elect a female candidate. Pursuant to the DNC's adopted parliamentary authority, a challenge to the elections alleging that the results are null and void need not be made at the time the improper procedures were used, due to the nature of the foregoing violations of fundamental principles of parliamentary law and a basic right of individual members. As a Democrat, one who, like the DNC, believes that free and fair elections are the bedrock of our democracy, and on behalf of the challenging party, I urge the committee to recommend to the DNC that the announced results of the 2nd and 3rd at-large vice chair elections are null and void because of the violations of fundamental principles of parliamentary law, the basic right of individual members to vote, and the equal opportunity and non-discrimination provisions of the DNC charter. Those 2 elections are incomplete and must be completed as soon as practicable at a regularly or properly called meeting of the DNC. And when those 2 elections are conducted, due to having different lists of candidates, the votes cast must be counted separately. The challenging party, Kaylin Free, thanks the committee for its careful consideration of this important matter. Honorable chairpersons, at this time, we will not call Kirsty Holland and reserve the balance of our time up to 5 minutes for rebuttal. Thank you.
Thank you. And at least according to my clock, that gives you 4 minutes and 34 seconds, at least what I saw there. Hopefully folks agree with me on that. Thank you. That concludes the presentation by the challenging parties other than their rebuttal testimony.
All right, thank you, Ryan. The challenged parties will now present their arguments. You have 30 minutes divided equally among the two respondents. I understand, Mr. Alam, you are representing Vice Chair Malcolm Kenyatta today and have informed us of a witness, Bradley Townley. You are recognized to present your case, and the time clock will begin once you are unmuted.
Thank you. Good afternoon, co-chairs, members of the Credentials Committee, and distinguished guests. Before I begin, I just want to disclose that I'm here in my personal and individual capacity and not on behalf of my employer or any political organization of which I'm an officer. Moving to our response. First, on behalf of Vice Chair Kenyatta, we would like to reaffirm our deep respect for all of the parties here today. While we disagree with the challenger's interpretation of the election results, we are grateful to be a part of a party built around transparency and due process. Now, turning to the issue at hand. The foundation of this action concerns the election procedure that was used during the DNC officer elections held on February 1st of this year. While the challenge purports to claim that this action is in regards to violations of the DNC charter, whereby procedures resulted in discrimination and the exclusion of women of color candidates, it fails to assert any allegation of wrongful conduct by Vice Chair Kenyatta. Every allegation in the challenge concerns only the election procedures that were provided to the voting members approved by the body and implemented by the DNC officers during the election. Also in direct contradiction to the allegations, this process led to the election of 2 women of color officers. Therefore, the allegations are objectively true on their face. Notably, the challenging parties expressly admit that Vice Chair Kenyatta is not at fault here. What is also clear, and which the challengers can't refute, is that Vice Chair Kenyatta won his election fair and square. No amount of numerical analysis of the votes cast can show otherwise. Now, turning to Vice Chair Kenyatta's response. His request to dismiss this challenge is founded on several reasons, and I'll go through each one now. And in addition to that, I'll ask our witness to testify. First, Vice Chair Kenyatta is not a proper party in this challenge. The challenge asserts numerous allegations regarding a flawed electoral process and alleged mistakes that were made by parties overseeing the balloting process. However, no allegations were directly asserted against Vice Chair Kenyatta for any wrongful conduct. Further, even the challengers admit that Vice Chair Kenyatta likely won his election to the second Vice Chair position. And accordingly, he's only named in this action because he shared the same ballot with Vice Chair Hogg. The third ballot here had 402 votes cast for mail ballots. The win number here was 201.5. Of the total votes, Vice Chair Kenyatta received 187.5, Hogg received 104, and there were 110.5 votes casted for both. Kenyatta only needed 14 more votes of the 110.5 to have won. And based on the ballot breakdown, which our witness will get into, there were 12 voters who voted for Kenyatta on all 3 ballots, and another 12 that voted for him on the second and third ballot. So in addition to the votes he already received and the votes that preferred him, he had more than enough to win outright. Second, the challenge is not timely. Contrary to Dr. Siebel's testimony, parliamentary procedure here dictates that the appropriate time to have raised this concern and objection was through a point of order directly resulting from the election results or at any point prior to the adjournment of the meeting. An election occurring within this body, such as the one that happened on February 1st, can only be contested through that point of order and seconded and then heard by the body. That didn't occur here, and contrary to their testimony, there is no continuing objection here. There's no continuing breach of any kind. Here, the challenge was not raised, and it is untimely. Third, the challenger lacks standing. Prior to the third round of balloting, the vice chair elections, the voting body passed a motion by a 2/3 supermajority that would eliminate additional candidates in each round, in addition to those that received no votes at all. Accordingly, the third round of balloting resulted in Kenyatta with 298, Hogg with 214.5, and we passed with 112. However, Free received 96 and Conrad received 91.5, leaving them with the least number of votes in that ballot. Even if we were to take out the ballots that were being contested for Hogg, Free and Conrad were still the two lowest vote getters on that ballot. As such, Free and Conrad would have been eliminated. The only candidate that would still be eligible to be considered in a subsequent round of voting would be Hogg and Repass. Therefore, the challenger does not have standing here to contest this election. Fourth, the requested relief would violate the charter. Here, the challengers have requested for a new election for the second and third vice chair positions. This relief cannot be requested because in doing so, it would violate Article 3, Section 1E of the DNC Charter, which requires that the 5 vice chair positions, secretary, treasurer, and national finance chair, be equally divided according to gender. Right now, there are 4 officers that are men and 4 officers that are women. Notably, after the election of the ASDC president, the makeup of the current officer list is equally divided. Accordingly, the challengers' request to be granted a new election for the second and third vice chair position can only result in 2 options. One, that the new election has 2 male candidates, or the new election has 1 male candidate and 1 non-binary candidate. However, the election of a woman candidate would violate the charter's gender parity rule. For right now, I have a couple more points, but right now I want to bring in our witness, Mr. Townley.
Good afternoon, committee members. I understand that time is short, so I will skip the pleasantries, but my name is Brad Townley, and I am also appearing here solely in my personal capacity, not on behalf of my employer. Also, one of the committee members from Utah and the former parliamentarian for the state of Utah's Democratic Party.
Thank you, Mr. Townley, for your time. I just want to start off with, can you tell us about your relevant experience as it pertains to this challenge?
That I was parliamentarian for the state of Utah's Democratic Party. Okay.
Can you explain the parliamentary procedures implicated here?
Absolutely. So one of the issues most at conflict here is whether or not is the timeliness of this challenge. As Dr. Siebold referenced earlier, right? Typically, an election must be contested only by raising a point of order. The general rule is that such a point of order must be timely. That's Roberts 46-48. And that in order for a point of order to be considered timely, quote, the general rule is that if a question of order is to be raised, it must be raised promptly at the time a breach occurs. After debate has begun, a point of order is too late. That's 23-5. Now, Dr. Siebold and the challengers are alleging that there's an exception to this timeliness rule under 23-6, which waives the requirement for breaches of a continuing nature. And if the DNC operated exclusively on Robert's rules, they would be correct, but we do have other governing documents. Roberts 2.2 states that an assembly or society is free to adopt any rules it may wish, even rules deviating from parliamentary law, and that those rules, once adopted by the organization, supersede any elements of Robert's Rules of Order. As noted, the 2025 Rules of Procedure for the election of the DNC officers 2C5 states that at the discretion of the chair, voting for each vice chairperson position will be conducted one at a time among all candidates of the appropriate gender, but highlighting at the discretion of the chair. And 4B3 states that a vote shall be final when announced by the chair, which would be the time at which somebody could raise a point of order. Now, even granting that the ballot put 2 questions before the body, that would not create an ongoing open-ended right to dispute the results in contravention of the timeliness requirement. In fact, Roberts 2710 explicitly permits, for the convenience of a body, the ability to combine multiple independent questions into a single vote. Quoting directly, sometimes a series of independent resolutions or main motions dealing with different subjects is offered in one motion. Now, at the demand of even a single member, that question would have to be divided, but the demand, again quoting, must be asserted before the question on adopting the series has actually been put to a vote. The prohibition or the requirement that the demand must be asserted before the question is put to a vote would not need to state that if it provided, as Dr. Siebold is alleging, this ongoing open-ended ability to challenge the results indefinitely after the effect. And this also extends to elections. Roberts 4634 expressly contemplates voting for multiple candidates to fill multiple different positions on the same ballot, even positions with different timelines.
Thank you, Mr. Townley. So my last question is, what are the options available as a remedy at this point, given your testimony here?
So based on where things stood, everybody understood walking into the February 1 election that we did not know who we would be eligible to vote for vice chair. The candidates who would be eligible to stand for vice chair would be determined based on the vote breakdown of the previous elections and the gender breakdown as such. At the time, we didn't know who the ASDC would elect as chair. One of those positions, or in that chair position, is also vice chair, one of the vice chair positions of the party. Now, per Roberts, after applicable federal, state, and local laws, the DNC's charter, or in this case constitution, is the highest authority governing our party. It supersedes the bylaws, it supersedes special rules, and it supersedes parliamentary procedure. Article 3, Section 1E requires that the 5 vice chairs, secretary, treasurer, and finance chair, be equally divided by gender, allowing for a variance of no more than 1. After the February 2nd ASDC election of Jane Cleave as chair, we now have 6 of 8 positions that are filled and uncontested. And per the charter, those 8 positions have to be balanced by gender with a variance of no more than 1. That cannot be suspended even by unanimous vote. The breakdown of the 6 uncontested positions is that we have 4 women and 2 men with the 2 vacant positions. The only available combination for the committee is to either elect 2 more men or 1 man and 1 non-binary candidate. After the results of the 3rd ballot, there are only 2 candidates who qualify to stand for election at this point to fill these remaining 2 positions. Those would be Vice Chairs Kenyatta and Hogg. So even were we to adopt the entirety of the logic of the challenge, the committee is then prohibited by that same logic from granting the relief that the members seek.
Thank you, Mr. Townley. So to continue on, for point number 5 of Mr. Kenyatta's challenge, the requested relief would disenfranchise DNC members. Contrary to Dr. Siebold's testimony, the remedy sought here by the challengers, namely overturning the elections and holding new races with a different candidate pool, a different process for voting, and a different electorate, would also violate the charter and disenfranchise members whose votes have already been counted. The proposed remedy would replace the imperfections of the former process with another flawed process that would disenfranchise members who have since retired, who have been replaced, who can no longer serve in those positions, and members who might be unable to attend the proposed redo election, in addition to all of the other candidates who will not have the opportunity to be considered by this new electorate. This challenge is therefore requesting relief that would be at odds with its own intended desire, which is purportedly seeking openness and fairness in the DNC elections. And finally, the charter, as stated by Mr. Townley, the charter is superseded. The charter supersedes the Roberts Rules of Order. Here, the challenge contends that parliamentary procedures were violated. However, the challenge fails to mention that explicit in the Roberts Rules is a provision that states an incorporated organization can draft a charter that supersedes all other rules. Here, in compliance with the charter and the rules of the procedure for the elections, Rule 2C5, it clearly states that the balloting procedure for vice chairs will be conducted at the discretion of the chair. There can be no claim that parliamentary procedures were violated since the DNC charter and the rules for the election supersede those rules and gave discretion to the chair during the election. In conclusion, it is undeniably clear that the election of Vice Chair Kenyatta was conducted in compliance with the rules in place at the time. There were no objections to those rules. Those objections were not made, and they are not considered timely now because they are not in a continuing nature, and it is inappropriate now to try and revive those rules after the fact. There is no basis to the question that the credentials of Vice Chair Kenyatta is at issue, and we request that the committee consider this challenge to be rejected. Thank you all for your time and consideration of this matter.
Thank you very much. Now we'll seek to hear from Mr. Wilson. He's representing Vice Chair David Hogg. Today, the production team will unmute your mic and you're now recognized to present your case, and the time clock will begin once you are unmuted.
Good afternoon, everyone. I am Graham Wilson. I'm counsel for Vice Chair David Hogg. He apologizes that he cannot be here today. He's unfortunately on a plane right now and some travel that was arranged in advance and couldn't be rescheduled. However, at the outset, I did want to communicate Vice Chair Hogg's respect for the challenger and the appreciation for all of Ms. Free's work for the party. Ms. Free's dedication to her work and engagement is obviously tireless, and anyone who takes their work for the party and the issues we're all fighting for so seriously should be commended. As that, at the outset, as initial matter, I also did want to recognize how this credential challenge is so different from the standard credentials challenges that come before this committee. Where usually the respondent to a credentials committee challenge was involved in some way, in some nefarious action to try and rig an election or affect things unfairly. There is absolutely no allegation that Vice Chair Kenyatta or Vice Chair Hogg did anything inappropriate in any way here. They actually had like no involvement or control over how this election was conducted any more than Ms. Free did. They did not advocate for the voting to be conducted in one manner or another way, or have any influence or power over how this election went out. They were honestly just candidates in exactly the same position that Ms. Free was in. To the contrary, how this election was conducted was according to the rules of procedure that was adopted by the DNC's Rules and Bylaws Committee. Those rules were then approved by the entire DNC, and the actual conduct of the election was run by the DNC chair in consultation with DNC counsel, instructions from the DNC's own parliamentarian, and Jim Roosevelt, who's chair of the RBC. So in some ways, this is a bit of an odd setup that we're here in the position of defending the DNC's own procedures, but so it goes. So let's talk about the voting procedures. Was this the best way to conduct this voting? I don't know. As an election lawyer, I do know that whatever the election rule is, even if it is a completely fair, neutral, objective set of procedures, vote by mail, early vote, for example, there's going to be a candidate that claims that that rule benefits their opponent in some way. And the challenger spends a lot of time on kind of complicated mathematical arguments, trying to set out that the way this vote was conducted was actually in our favor and disadvantaged them. Would it have been better to do these two separately? If they did them separately, would it have been more fair to do the open seat first and then the mail seat second? Or would that have actually given an advantage to one set of vice chair candidates or the other? Should all of these elections should have been done together, but with a different set of voting instructions so that you could vote for either a male or a female candidate or two males or two females and then take the top two. If a different sequence of voting was being used, who would that have benefited? Would it have the benefit to one gender or the other, but then end up actually having a negative impact to other diverse candidates who are running in this race, given the specific identities of the candidates who are still left at that particular moment? There are honestly like a lot of different ways that this vote could be conducted, and I'm quite confident that no matter who which matter was selected by the DNC, that one candidate or another could have claimed that it hurt them in some way or benefited one of the other candidates. What I do know, though, is that in all of the rounds of voting, including in the first two rounds of voting, where there was no limitation on which gender candidates that DNC members could vote for, in none of those rounds of voting did Ms. Free even get half as many votes as either Vice Chair Kenyatta or Vice Chair Hogg independently received. On ballot one, where Artie Blanco got the most votes, Vice Chair Hogg got 61 votes, Kenyatta got 54 votes, and Ms. Free got 24 votes. On the second ballot, the one that elected Artie Blanco to Vice Chair, David Hogg won, getting 149 votes. Vice Chair Kenyatta got 135 votes, and Ms. Free got 54.5 votes. And then, as we know, on ballot three, Kenyatta got 298, Hogg got 214.5, and Free got 96. So this isn't a case where there was a more popular candidate that suddenly found themselves on the losing end of this because of the way that voting was conducted or rules changed at the last minute. On the 2 previous votes that were open to any gender, they were Hogg and Kenyatta were clearly the 2 favorites after Artie Blanco, and they each got more than twice as many votes as Ms. Free got. The voters' preference here actually seems pretty clear. What I also know is that while you can argue about one approach to this election or the other, the method of voting here that the DNC chair selected clearly complied with the DNC charter, bylaws, and the rules of procedure. So let's break those down, starting with the charter. A lot of what makes all of this unique is the DNC's relatively rare requirement that we have equal division amongst our DNC officers. And this provision of our charter creates a unique situation that makes this different than the generic kinds of elections that Robert Rules is considering. But there's no question that the DNC appropriately conducted the election to end up with like an appropriate equal gender division at the end. So the challengers also then cite to several provisions of the charter regarding full participation. Article 8, Section 1, for example, the Democratic Party of the United States shall be open to all who desire to support the party and with to be known as Democrats. Section 2, discrimination in the conduct of Democratic Party affairs on the basis of sex, race, age, if of voting age, color, creed, national origin, religion, economic status, sexual orientation, gender identity and expression, ethnic identity, or disability is prohibited, to the end that the Democratic Party at all levels shall be an open party. It is clear that the DNC in this particular election was open to all, and the DNC was not engaged in any kind of discrimination in the officer elections. I think, as we all know, this final slate of officers included multiple women of color, and we should be proud as Democrats that our officers represent such a broad range of genders, sexual orientations, races, ages, and characteristics. There was no discrimination in the conduct of this election, apart from distinguishing among genders, but only as necessary to comply with the charter in order to meet the requirement and obtain equal division. So this actually isn't a question of discrimination under the charter. What this whole challenge fundamentally comes down to is not discrimination, but election procedures. And the procedures that were used, albeit maybe they were imperfect, messy, maybe they were not clear in advance because there were some changes that were made to accommodate a non-binary candidate. These procedures clearly complied with the DNC charter, the bylaws, and the rules of procedure. So given the need to achieve equal division, the rules of procedure set forth that the DNC chair should have the discretion in order to either have voting for each vice chairperson one at a time of all candidates of the appropriate gender, or subject to their discretion, they can do this all at once. The rules of procedure that were adopted by the RBC and adopted by the entire DNC also state that, quote, in the election, note singular, of the 3 remaining vice chairpersons, provisions will be made to elect the appropriate number of persons of each gender in order to achieve equal division. So the challenger claims that was what was required here. The challenger claims that what was required under Robert's rules of procedure was that there be 2 separate elections. But the DNC's own rules of procedure explicitly state that that exact question was left open to the chair. So you have the challengers claiming that Roberts requires something, but our own rules explicitly say that that's not required, that the DNC chair actually has the choice whether to do an election for a vice chair slot one at a time or all together. So could someone have argued that it would be better for the DNC chair to have made a different decision in that moment or conduct this election differently? Sure. But it was clearly his decision to make, and it was a valid final decision under the rules. If there was an advantage to male candidates, it was only because one of the 2 candidates elected from the authorized joint vote was actually required to be male under the charter. The RBC could absolutely look at whether these rules should work differently in the future, but for the rules that were actually in place at the time of this election and the way it was conducted, it was absolutely in full compliance. So since there was no charter violation and the election complied with the DNC rules, what you see the challengers doing here is reverting almost purely to an argument that there was a problem under Robert's Rules of Order. But Roberts, why are we even talking about Roberts? Roberts is only relevant because the DNC charter says it's relevant and that the DNC charter says that we'll use Roberts. But what the challengers expert, throws into a footnote is that the language in our charter says that, hold on one second, that in the absence of other provisions, Robert Rules of Order, as most recently revised, shall govern the conduct of all of Democratic Party meetings. So it is only when the DNC's own charter and bylaws and rules are silent that we turn to Roberts at all. And here it wasn't silent. We have an explicit rule in our rules of procedure adopted by the full DNC, explicitly setting forth that the chair had the discretion to conduct the election in exactly the way that he chose to do so. They also make the argument that Roberts requires separate votes because this was more than one question at a time. But again, under the adopted DNC rules, which ultimately govern, it clearly allows for more than one vice chair spot to be voted on at a time. And given the unique gender role divisions, some of those slots may need to be designated for one specific gender or the other. So the general Roberts rule here is trumped by the specific and higher authority DNC rules. So look, not surprisingly, the person that the challengers have paid to interpret Roberts in their favor has cited, I think, a little bit selectively from Roberts and only provided the committee in their exhibits with some favorable provisions of the rules. Dr. Siebold refers to Roberts Rule 4633, stating that it sets forth the way that multiple seats on a board may be filled at the same time. But look, again, he doesn't reference the language at the top of that section where Roberts kind of sets forth a number of ways that organizations can do voting, which says that in an assembly or organization that does not have a rule or established custom prescribing the method of voting in elections, the voting can be done in any of the following acceptable methods. We obviously, as an assembly and an organization, do have established rules and customs dictating how our elections should be conducted, and those are the ones that we followed here. Dr. Siebold also points to Rule 4633 on how elections for multiple offices at the same time should be done, but he doesn't reference Rule 4643. Which discusses how an organization may decide to fill multiple positions at the same time by voting on all of the candidates at once and giving each member more than one vote. Now, how it's set forth in 4643 is not exactly how the DNC conducts its election, but that rule states that the method, quote, must be viewed with reservation since it violates the fundamental principle of parliamentary law that each member is entitled to one and only one vote at a question. So you hear the challengers over and over saying this is a fundamental principle of parliamentary law under Roberts, and accordingly the DNC was wrong to do it their way. But even Roberts recognizes that an organization has the authority under its own charter, bylaws, and rules adapted by the whole membership to conduct an election in ways that do raise questions under fundamental principles of parliamentary law, if that's what the organization decides to do and conduct its election in that manner. Siebold also makes an argument that it is still appropriate to raise this challenge, even though no one made a point of order or an objection at the time the rules of procedure were adopted, or at the time the DNC chair announced that he was going to conduct the election with 2 vice chair slots at the same time. And yet, nowhere in his opinion does he reference or cite in any way to Rule 4648, which concerns, quote, contesting the announced results of an election. How are we supposed to take this opinion as authoritative here when we're not even discussing the contesting the announced results of an election rule in the discussion of some contested results of an election? So, of course, there are There are, of course, exceptions and exceptions to exceptions in all of these rules. But the point is that despite Dr. Siebold's credentials here, he is not giving an authoritative, neutral interpretation of these rules. And look, I'm quite confident that he can come up with some rebuttal arguments under Roberts to everything I've said. He is obviously a parliamentarian expert, and I'm, in fact, not even a parliamentarian. However, lucky for us, the DNC actually has a neutral parliamentarian, and her name is Helen Fadden. And she was the parliamentarian who was overseeing the DNC meeting and advising the chair on how the election should be conducted. And I think we can rely on her guidance. In conclusion here, honestly, there could, of course, been different positions on the ideal way to have best conducted these votes. And you can see that like skilled experts on both sides can come up with different arguments about how the rules should have been interpreted. But I do think it is inappropriate to try and challenge the election rules and procedures that everyone was operating under after the fact. No one ever raised a point of order. No one ever raised an objection. And when the DNC chair exercised his discretion as Roberts requires. And even if there's a fact that it would be permissible to make an objection at this time, I think it would be inappropriate to do so, which would amount to a disenfranchisement of the clear will of the DNC voters. The vice chair candidates who repeatedly won the most votes all day at the DNC were elected. And the DNC elected multiple women of color, diverse candidates.
Your time has expired.
There was no discrimination.
Okay. That concludes the presentation by the challenged parties. At this time, thank all the parties for joining us today and for the time and effort you have expended on your cases. The committee will now take 30 minutes for debate.
No,
Andrew?
we still, I don't mean to interrupt.
Oh, I'm sorry.
Chair. We still have the challenging parties previously reserved 4 minutes and 34 seconds for.
Sorry.
Yes, ma'am. Yes, ma'am.
Jumped.
Nope. The challenging parties now are now recognized. The challenging party represented by their attorney is now recognized. Ms. Roll, you are now unmuted. The timer will now begin.
Thank you, Mr. Chair. First of all, I'd like to clarify something that was raised by Counsel for Representative Kenyatta. There is no question about the balance of the positions filled by each gender prior to the third ballot for the vice chairs. It was that 2 men had been elected for all the included offices and 3 women had been elected. That is why there was an effort to elect another male, and that is why someone of any gender be elected to the last at-large vice chair position. Next, I would like Dr. Siebold to respond to some issues that were raised. I'm pretty sure that Dr. Siebold agrees that the DNC charter is the highest governing document of the DNC other than the law itself. And that's followed by the bylaws, special rules of order, standing rules, and then the parliamentary authority. Please tell me if you agree with that and whether there are any rules contained in any of these governing documents that somehow negate the 2 fundamental principles of parliamentary law and the basic right of a member to vote as you laid out in your report.
Yeah, I think that's correct. I mean, the charter is the highest authority, the bylaws next, and these things supersede the parliamentary authority, which in this case is Robert's Rules of Order, newly revised. But there's nothing in the charter that says or even implies that you can take the votes on 2 different questions and simply count them simultaneously. There was an effort, I think, to quote from some provisions of R&R. One of them was, I think, paragraph 2710, stating that, well, it's really okay to vote on several things at the same time. That's actually describing a situation where you have a single ballot on which there are spaces, sections on the ballot to vote on several different questions. It doesn't say you count the votes together. I mean, if you're trying to decide whether to adopt Bylaw Amendment 1 and Bylaw Amendment 2, you can indicate your yes and no to those two questions on the same ballot, and they're counted separately. You'll just tally up all the yeses on two questions and then tally up all the noes and try to figure out what happened. So that's what that issue is. It is absolutely true the charter can authorize a violation of the fundamental principle of parliamentary law. That's what cumulative voting, which was cited in 4648, is. But the bylaws don't authorize. They don't say anywhere that you can take the votes from two separate questions and combine them.
Would you please again describe continuing breach and why it is the testimony that we've heard on continuing breach does not capture why it is other than your testimony, that is, why a continuing breach existed here and allows for an objection to be made after adjournment of that meeting where these elections were held?
Yeah, well, the last speaker actually addressed this by quoting from 4649 in the book. I have the book in my hand here. And it says the general rule is that a point of order must be timely. This is referring to election challenges. Other exceptions to the general timeliness requirement are those that come within the 5 categories listed in 23.6. This is what it's like to be a parliamentarian. You're constantly flipping back and forth in the book. But 23.6 lists the specific exceptions, and those specific exceptions include any action that has been taken in violation of a fundamental principle of parliamentary law and any action that violates a basic right of an individual member. So the problems here related to the fundamental principles and the basic rights that I've identified are exceptions under the rules.
Thank you, Dr. Siebel.
Okay, members, now we're gonna go to question and answer for 30 minutes. The committee now has 30 minutes for debate, and during that debate, members may address questions to each party's counsel or representatives. Individuals who are not members of the committee may only speak when recognized by the co-chairs and will be unmuted by the production team when requested to do so by the committee. So members, if you have any comments or questions, please raise your hand via Zoom or send your question via chat to the DNC support. And we'll do our best to call on everyone in order to seek a recognition, but please be patient with us. So I'm being told that we do have several hands up. I know Michael Kapp, you had 2 questions, and then we'll go on to, I see Christine Pelosi. Go ahead, Michael.
Thank you, Supervisor. I have 2 questions for Dr. Siebold. First, the rules of procedure passed by the RBC and ratified by the full DNC on January 31st clearly state in section C5 that the chair has discretion. But you said just now in your rebuttal that there's nothing in the charter that says that we could take votes on 2 different questions and count them simultaneously. You're correct, that wasn't the charter, but it was in the rules of procedure which control. The rules of procedure say that the chair has discretion, which in theory, in your words, could then take votes from 2 separate questions and combine them. Is that not accurate?
No, that's not the case at all. What the rule says, I've got it in front of me, it says at the discretion of the chair, voting for each vice chair position will be conducted one at a time among all candidates of the appropriate gender. So the question is, if the chair does not exercise her discretion to do that, but instead takes the votes on both chairs simultaneously, what is the correct procedure? The correct procedure is not to say, okay, there are going to be 800 votes out of here, 400 of them are just for the men. The other 400 are shared among everybody, and we'll just see who winds up with the most votes. That's not the procedure. The procedure that could have been used in this case, it's a little bit more complicated, is you allow each voter to cast 2 votes for any of the 5 candidates. You look at who comes up at the top and declare them elected, assuming they have a majority. You look at who comes next. If they have a majority, you declare them elected, unless that would violate the charter's rules on gender parity, in which case you declare no election and go on. So the chair certainly had the discretion. The requirement, and I may not have made this very clear, but the requirement that this be conducted as two separate votes and the votes be counted is an artifact of the way the questions were framed, because they were expressly framed as choose one of these two and choose one of these five. You can't simply combine them into one single tally of votes as if these were all votes on the same question. That was the problem.
Thank you for that. That leads me to my second question. And if we can turn to Roberts, section 2710 states that when a motion has two separate questions, any single member could have demanded a separate vote and it must be accepted. However, section 2710 also states that the demand must be asserted before the vote actually occurs. It says, and I quote, "This demand must be asserted before the question on adopting the series has actually been put to a vote. The facts here have shown that no one made such a demand before the vote was taken." How do you square this circle if we're only focusing on Roberts?
Yeah, no, you're right. But this refers to a completely different situation. What 2710 says is sometimes, I'm quoting here, a series of independent resolutions or main motions dealing with different subjects is offered in one motion. So an example of that might be there are 5 resolutions to be considered, and someone says, I move the adoption of resolutions 1, 2, 3, 4, and 5. Now, if that question is put to the assembly, it is a single unitary question. A vote yes is I want all 5 adopted, and a vote no is I don't want them. If you feel that one of those questions should be voted on separately, you pull it out. But that's a completely different situation than what's going on here. If someone had made the motion to say, I move that Kenyatta and Hogg be elected, and a majority of people had voted in favor of that, as far as I can tell, that would have been perfectly proper. But that's not the issue here. In this case, you had separate questions being posed, separate votes being offered, and all of them tallied together. That's not what this is talking about. This is talking about something completely different, where you're simultaneously adopting several motions at the same time and voting on them as a single unitary question.
Thank you, Supervisor.
Yes, Christine Pelosi. Please unmute.
Thank you. I had a question for both, I guess all 3 council, and that is to please address what the Challengers Council was talking about, deeming the election as incomplete. And yet, as Vice Chair Kenyatta's council pointed out, to do so and have a new election would mean that you would have a new election with a new set of DNC members. So how do you how do both sides square the circle of the remedy? If we are to accept Dr. Sebald's argument that the election is merely incomplete and we simply come up with 2 more ballots or rounds of balloting with the same, I assume, the same 5 candidates, how do we not disenfranchise DNC members who are no longer on the DNC at this moment? And would we be bringing them back, or are you contemplating continuing the election with a new electorate? Question for both sides, please.
A vacancy. Thank you, Member Pelosi. I'll answer first and then I'll defer to our expert if that's all right. This sort of thing happens all the time, where the defined electorate changes between meetings, the offering of a question that might be postponed to a later time, and an incomplete election, which the expert has alluded to here. So I will let Dr. Sebald elaborate on that.
Yeah, I don't really have much to add to that, except to say, yes, I mean, the people who speak in the name of the assembly at any given time are the members of the assembly. It's a fairly normal thing over time that motions get adopted by one group of members, and then at some later date, a slightly altered group of members rescinds or amends that particular motion. If one group of members thought that they took proper action on a particular question, and it's subsequently determined by on a point of order or some other process that the motion was not properly adopted, then the people who will settle that question when it rises again are the people who are the members of the assembly at the time the matter is raised again.
May I jump in?
Go ahead.
So our response on behalf of Vice Chair Kenyatta is that it simply can't be squared away. I think the ballot had been completed, the election results were complete. So it's not an incomplete ballot, contrary to what's been testified to. So the election is over. The results were that Vice Chair Kenyatta and Vice Chair Hogg won their election. Two, on regard to the procedural issues here, I don't see how there would not be disenfranchisement here. If we were to have an election right now with the current membership, that means an entire body of people who voted the first time can't vote again, and they can't square away the issue with the gender parity rule. All of the same candidates that were on that ballot cannot be candidates now, because there are 8 officers. According to the gender parity rule, 4 of them are men and 4 of them are women. And so if these 2 seats were brought back into an election, only men candidates could run for these seats because a woman candidate would shift the gender parity rule. And so I don't think the issues can be squared away here.
I agree. And I think that this question really gets to the practical heart of the matter. Of course, the election was complete. The DNC voted, the votes were cast, everybody examined the votes. They were done so under Jim Roosevelt's supervision and the DNC's council supervision. Everybody agreed on what the rules were going into the vote. The vote was run, and we all saw who the winners were, and they were the same winners who had been receiving the majority of the vote for the day. It would obviously be turning things completely on its head with new DNC members to have what would fundamentally be a brand new election. And a quibble of exactly how, after, I don't know, what was it, 13 hours in, like exactly how the motion was teed up and whether it was, worded this way or if you worded slightly different way, Dr. Siebold says it's fine, we're 13 hours in here at a DNC meeting, and the election was done. It would be completely inappropriate to redo the whole thing.
Okay. I will now recognize Wendy Davis.
Yeah.
Go ahead. Start all over. I'm sorry.
They have, okay, there, my audio is undone now. Thank you very much. I have a number of questions. First of all, for Mr. Townley, I was wondering if you're a member of the National Association of Parliamentarians or the American Institute of Parliamentarians, the 2 leading organizations in the U.S. of parliamentarians. And if so, have you earned any of the industry standard credentials from either of these organizations?
I am so sorry, ma'am. I'm still at my office and we're having a little bit. Can you rephrase that question one more time?
Sure. Are you a member of the National Association of Parliamentarians or the American Institute of Parliamentarians?
Not at this time, no.
Okay. I mean, a lot of people do great work as parliamentarians without that, but just wanted to see what standard or credential you were using for your analysis. Thank you very much for that answer. I wanted to address Dr. Siebold. And Doctor, I was wondering if you could tell us, again, I think I heard you say that the issue was the combination of the 2 baskets of votes, and your report asserts that that's that combination of those 2 baskets of votes that creates the violation of our charter requiring gender parity. Am I restating that correctly?
Well, I mean, I think there are two issues. There's the sort of parliamentary issues involved, and then there's the issue that gets into the charter's requirement that there not be discrimination. In regard to these two, I mean, think of them as two big pies, all right? The DNC came along and baked two big apple pies and set them before the candidates and said, okay, the pie on the left, only the men are allowed to eat from that pie, okay? But all five of you can share the other. And whoever winds up eating the most, that's who we're going to determine to be elected. So the issue is, the intention, as far as I can tell, was to make sure that one of the two male candidates got a majority, was listed on a majority of ballots, and that the other candidate had, an equal shot, with the others. But doing this, reserving, in effect, 400 ballots just for the men that the women couldn't touch, that essentially gave such a huge a head start to those two men. It essentially guaranteed that, of course, they would finish at the top. So the charter issue that we raised is simply that that particular, that's a discriminatory process with regard to creating this situation where the men were virtually guaranteed to come at the top. That was that issue in regard to gender. I'm not sure if that answers your question properly.
Thank you. I appreciate that. I think we spent a lot of time, and I remember my colleague, Ms. Pelosi, helping us with trying to reduce the number of people on the ballot and making sure we were very careful to reduce an equal number of men and women. But I don't think we looked at how the math was going to be impacted when we left it as just two men competing on those 400 ballots. Obviously, with only two candidates, unless there's an absolute tie, which would be highly unusual, one of those people is going to achieve a majority. And it seems the problem here, clearly, the women on the 400 ballots they had access to got more than 300 votes of those 400 votes that were available to them. But it's that first basket or first pie where we took the extra slices and added it to the supposed, from the slices that the men shared in the second pie, right? That enabled us to get a second man who achieved that more than the majority. Whereas mathematically, it was virtually impossible for any of the women to do that. And I think that the trouble lies therein, right? That and obviously we've spent a lot of time thinking about Robert's rules and the charter and the bylaws, but to me, because we didn't have separate lines on that ballot and because we combined all those numbers, it was patently unfair to the female candidates. And I know one of the gentlemen, said that earlier throughout the day that the men were getting more votes than the women when they had a fair shot at all the votes. Well, again, I contend to you that we had a larger number of well-qualified women and well-supported women candidates than we did of the male candidates. There was sort of a consolidation in a way, and which is why you saw that we removed so many men from the ballot. So we were only left with two. And so I think that that's why we did. It was a problem. And I think it's incumbent upon us to figure out a way to solve this problem rather than to say, oh, well, too bad, maybe we shouldn't have done it that way. So I do have one more question. I wonder, Chairs Ramirez and Solis, if it would be appropriate, since we've heard from Dr. Siebold about his conclusion that the DNC charter and our parliamentary rules of order were violated. Somebody mentioned that our parliamentarian, Helen McFadden, was present.
I think the questions are to the parties.
Okay. I can't.
I mean, and you're really going on in terms of arguing.
Thank you.
Associated with. Okay. Thank you.
Great. So let's recognize Governor David Walters.
My first question is to Mr. Elam, counsel for the respondents. Mr. Elam, would it make a difference to you, your argument that a woman cannot fill the final position for all gender because we're out of gender balance, if you knew that the DNC exempts the ASDC president as it does the chair of the party from consideration in that count?
Sorry, there was a bit of a delay. It's my understanding that the AFDC president would not have counted at the time that the election was going on, but now since that position has been filled by a woman, that count now impacts the overall board makeup. The only position that is exclusively not included of the overall count is the chair. The provision that relates to the AFDC president is that the election can occur without that being impacted, but when it's reversed and that position already is filled, and then positions on the DNC vice chair positions open up, then the numbers are impacted. I guess for a better understanding of this, if I may, I can bring in Mr. Townley to kind of describe that issue.
I think you've answered the question. The DNC has clearly exempted the ASDC from the count on the gender parity, and there's nothing in the rules that suggests that a before or after circumstance. I wanted to also ask how, I know you all, and maybe this, I'm sorry, I should direct this to Mr. Graham or to Graham Wilson. Mr. Wilson, how does, I know you referred to it as a quibble and a minor thing and back and forth. How do you rationalize that since we had two questions, which male is going to fill the male position, which group out of the 5 remaining candidates, which person is going to fill the all gender position, how do you rationalize that the women had access to 411 votes and the men had access to 817 and say that because they weren't separated, therein lies the error, of course, a big error, that they were not segregated for the count. They were not separated on the count. We had a 2-line ballot. They weren't instructed to put one on one line, one on the other. And so we had 2 questions, but a single count. And yet we had this double access to votes. How is that fair and considered by you a quibble?
Yeah, look, I absolutely get with what you're saying. And I wasn't describing that as a quibble, but at some point, Dr. Siebold said, well, if the question had been presented this way, then, it would have been fine. Use the term quibble to try and get the point across that I think that there's a lot of technical arguments that were being made under Roberts to get under this exception or get under that exception, but that the DNC members knew what they were doing and knew who they were voted for, and no one made an objection at the time. The other point I would make in response to your question is that in section C5 of the Rules of Procedure, which is the DNC rules now, not Roberts, it's the DNC rules that the DNC adopted for how this was going to go. The rule refers to, in the election, singular, of the 3 remaining vice chairs, provisions will be made to elect the appropriate number of persons of each gender. Now, Dr. Siebold says, well, here's the way I think that should have been done. But with all due respect to his expertise, the DNC chair came with this rule that the DNC adopted, contemplating that there's one election actually for all 3, and that they would take some procedures to make sure that the gender division worked out the right way. And only in his discretion then do you go to 1. So what is the right provision will be made? What is the exact right provision in order to achieve that gender disparity, which is the unique, or gender parity, which is the unique thing our rules required? I think there's a lot of ways you could do that. And at the time, the DNC chose one. He consulted with the DNC parliamentarian. No one objected at that moment that there was anything wrong with that, and the election went forth. And so I think after the fact, that doesn't give a basis to go back and try and do it all over again.
Thank you. If I could ask Dr. Siebold to comment on similarly, I wanted, Doctor, to ask you that one of the things that could have been done on the instructions to correct this rather than just running the whole thing as a general vote, would have been to provide that instruction to put on one line the vote for the male position and to put on the other line the vote for the all gender position, so that we would have had in the all male position, instead of 512 votes cast for males, we would have had 411 cast for the male position, and there would have been 100 or so male ballots that would have shown up in the all gender position. And based on the fact that there were 300 ballots already for women, would that not have, we can guess about how that would split out, but almost certainly the two candidates, if that had happened, Kenyatta Hogg would have come in 4th and 5th place in that balloting if it had been properly separated and counted. Do you agree with that?
Yeah, I think that's probably right. The issue here is that when you're electing for multiple positions, let's say you're electing a president, a vice president, a secretary, and a treasurer, it's perfectly normal to have a single ballot. And in the top of the ballot, you indicate your vote for president, and the next section for vice president, and so on down. But when you cast multiple votes like this on a single ballot, each section is treated as though it were a separate ballot, and the votes are all counted separately. So the person who gets the majority for president becomes president. The person who gets the majority for secretary becomes secretary. In this particular case, if we had split it in that way, then the 400 ballots for the male-only candidate would have been split between Kenyatta and Hogg, Mr. Kenyatta and Mr. Hogg. The other 400 would have been split before all five. As you point out, women claimed, I think, around 300 of those ballots. So the remaining roughly 100 would have been split between Hogg and Kenyatta, and in which case it appears that no one would have received the majority to be elected to that position, and a new ballot would have been required.
And thank you. Thank you very much.
Thank you. We do, Don, we do want to be fair with our time. I see Mr. Clay Middleton, he's had his hand up there. Go ahead.
I appreciate it. This is for Mr. Sebo. When you were talking earlier, you mentioned continual breach, and you said it again at the end, but I had a delay in corresponding to that. When you said it the first time, were you saying that the continual breach was because something didn't happen properly, then everything that followed is null and void?
Yes, that's exactly it. So again, what you're hearing here is correct. Most of the time, if you breach the rules, someone says right at the moment it happens, oh, point of order, and then it's addressed. It's actually really, really rare to have a procedural breach that is of such severity that you don't have to raise it right at the time it happens. But when you do have such a breach, it's called a continuing breach. And, it's specifically stated, and I think we cited the line before, that in the case of an election, you can challenge the election long after the fact on the basis of a continuing breach that is a violation of the fundamental principle of parliamentary law, or a violation of a basic right of an individual member, including basic rights to vote. So as an example, if, after all of these ballots, you got kind of tired, you wanted to take a break, and you went into another room, a group of Republicans broke into the room, grabbed the ballots, filled them out, and, proceeded to elect certain people. Okay, that's a violation of the fundamental principle that the right to vote is limited to the members of the assembly. So if for whatever reason you didn't figure this out until 2 months later, it's not you snooze, you lose. You can actually raise the issue even at that time. So the fundamental principles of parliamentary law that were breached here do create continuing breaches and allow this matter to be raised after the fact.
Okay, thank you.
Are there any other hands raised? Seeing none. Still have time, but if there are,
I think that's it.
we can move on. Very good. Okay, I turn it over to you, Ryan.
Chair, I do see David Walters Governor Walters' hand is raised.
Oh,
And
okay,
these are for questions, right? Not debate.
right.
And of the attorney for the challenger. Is she on?
I am.
Hello.
Hi.
Yeah, I think my question is in regards to this, in regards to the timeliness, how long did it take the challenger to get, because it required getting the ballots, understanding the ballots, trying to figure out what happened. Hardly anybody on the floor, there may have been one or two people that understood that this was perhaps going to be biased, but hardly anybody on the floor seemed to realize that. And how long did it take you to get the ballots so that you could properly analyze them and determine what had happened?
The challenger in this case started in almost immediately investigating the matter, but it did take her a full 3 weeks in order to obtain all the necessary information to file her challenge. And she diligently sought that information during that time and filed her challenge within the time frame of that is stated within the rules for doing so. And in that sense, it's kind of interesting to me because a continuing breach, the notion of it is that, it is indefinite, but your rules actually kind of bookend it a bit with having to file a challenge within a certain amount of time, which Kaylin Freed did.
Thank you.
Ryan?
All right, I think we're done now.
Oh,
And-
one more. Oh, Michael Cap. Go ahead, Michael.
Okay.
Thank you,
Go ahead.
Supervisor. Thanks, Ryan. One question for both Brad Townley and Dr. Siebold.
Yes, sir.
Go ahead, Michael.
Hi, sirs. I'm just wondering if you're being paid for your testimony to be here today.
I am not.
I am.
Thank you both.
Okay, thank you. I see no other hands, and Ryan? Your way.
Going once, going twice. So, first and foremost, thank you for the thoughtful questions and discussion. I think, as a party, we should be really proud of our opportunities to sit here and work within the family to hear challenges and work together. At this time, we will consider a resolution to dispose of the pending challenge. I would like to recognize Ms. Pelosi. Ms. Pelosi, do you have a resolution you'd like to present?
I do. Thank you. And thank you to everyone who presented and everybody who asked questions. I have reflected on this a lot as I was reread everything again this weekend and prayed on it. I just feel that we had a proper election. I don't just feel it. The facts demonstrate it, as was referenced during the prior questioning during the meeting itself. When the chair from Florida made a motion to restrict the number of final candidates, I actually objected to that motion. And that was at about hour 8 or something, hour 9 maybe of the meeting, and said, wait, let's carefully consider what we're doing here to make sure we have gender balance and rural participation in this vote. And I believe everybody, most everybody I spoke to, certainly, when this vote was being cast, were very clear that this was the vote that could be dispositive. I got to the DNC on a slate. Many of us are elected on the slates where you vote for multiple candidates at once. the top self-identifying females are elected, and then the top other candidates are elected, even though it could be that the women win many more votes than the men, or vice versa. It's still tabulated out to the winners. And so the top vote getters in each category. So I think we knew what we were doing as a DNC collectively in the moment. And I think the time to have made any points of order or change the rules was when we were in fact changing the rules in the middle of the election. And I also believe that there isn't an ongoing breach, and that any new election would disenfranchise everybody who was in that campaign and in that room. And so therefore I would move that we uphold the election of Vice Chair Hogg and Vice Chair Kenyatta and respectfully dismiss the challenge.
Do we have a second? Michael?
I would like to second that motion. Thank you.
Thank you. Oops, I muted myself, sorry. A resolution has been offered and seconded. It is just, in just a moment, Party Affairs will display the proposed resolution on screen. Per our rules, the proposed resolution will be discussed for a maximum of 20 minutes with equal time divided between the proponents and opponents of the resolution. If the credential if the credential members wish to recognize, please raise your hand now via Zoom and state at the beginning of your remarks whether you are proponent or opponent for the resolution. And again, each side has 10 minutes. I don't know if we want to take the second to have someone read through the resolution first, or because it's going to be hard to say if you're an opponent or proponent without seeing the whole resolution. So,
Chair, if it's helpful, I'm happy to read through the resolution and we can scroll along with it as I go through, if that's helpful.
I would appreciate that before we start the clock.
The resolution submitted by Christine Pelosi and seconded by Michael Kapp reads, in the challenge before the Credentials Committee, the Committee of the Democratic National Committee, the DNC, filed by Kaylin Free, the challenging party, to the credentialing of Malcolm Kenyatta and David Hogg, the challenged parties, as vice chairs of the DNC, and by virtue of that position, members of the DNC, the committee recommends as follows. Whereas on February 1st, 2025, the DNC held its elections for DNC officers for the 2025 to 2029 term. Whereas after the DNC had elected its chair, treasurer, secretary, national finance chair, and vice chair for civic engagement and voter participation, it began the election of its 3 vice chairs. Whereas the DNC charter and bylaws require gender balance among the DNC officers, and that the vice chair positions be used to ensure that gender balance. Whereas the DNC elected 2 men and 2 women as treasurer, secretary, national finance chair, and vice chair for the civic engagement and voter participation chair, as such was required to elect 1 female vice chair, 1 male vice chair, and 1 vice chair of any gender for the 2025 to 2029 terms. Whereas the rules of procedure of the election, as adopted by the DNC, provided that, at the discretion of the chair, voting for each vice chairperson position will be conducted 1 at a time among all candidates of the appropriate gender. Whereas in prior elections with rules granting the chair the same discretion, members were instructed to vote for multiple candidates at once for the purpose of electing multiple vice chairs at once. Whereas for the first ballot, members were instructed to vote for 1 candidate of any gender, no candidate received the majority of votes needed to win. Whereas for the second ballot, members were instructed to vote for 2 candidates of any gender, and Artie Blanco, a woman, received a majority of votes needed to win. Whereas after the election of Artie Blanco, the DNC was required to elect 1 male vice chair and a vice chair of any gender. Whereas prior to the third ballot, a motion to suspend the rules was made and adopted from the floor to allow for the simultaneous elimination of any vice chair candidate who had received no votes on the second ballot, as well as the remaining lowest 4 vote getters, balanced by gender. Whereas prior to the third ballot, another motion was made and adopted that anyone who has dropped off the ballot previously cannot be added back on subsequent ballots in order to conduct a continuous election. Whereas this led to the elimination of all candidates but 5, Malcolm Kenyatta, David Hogg, Shasti Conrad, Kaylin Free, and Gina Repass. Whereas members were instructed once again to vote for 2 candidates, but were also instructed to vote for 1 male candidate and 1 candidate of any gender. Whereas no point of order was made when Chair Harrison announced his instructions for the 3rd ballot, nor at any other time before the meeting adjourned. Whereas upon the conclusion of voting and tabulation, Chair Harrison announced that a majority vote on the 3rd ballot would be 205 votes, and that Malcolm Kenyatta and David Hogg were elected with 298 and 214.5 votes respectively. Gina Repass received 112 votes, Kaylin Free received 96 votes, and Shasti Conrad received 91.5 votes. Whereas this result was gender balanced and therefore complied with the DNC's charter and the election's rules of procedure. Whereas on February 28, 2025, Kaylin Free and Gina Repass filed a challenge with the committee alleging violations of the DNC's charter and unnamed provisions of the election rules of procedure and Robert's Rules of Order. Whereas on March 17, 2025, Chair Repass withdrew from the challenge. Whereas on April 10, 2025, Vice Chair Kenyatta and Vice Chair Hogg submitted their answers to the challenge. Whereas on April 11, 2025, the co-chair scheduled a virtual hearing to consider the challenge. Whereas on May 7, 2025, 7 DNC members, Henry Chamberlain, Dana DeRee, Juanita Brown Kawamoto, Johnny Roebuck, Jamie Selsler, Michael Wenstrup, and Corey T. Williams, the intervening parties, requested to intervene in the challenge, and their request was granted. Whereas on May 12, 2025, the committee held a virtual hearing to consider presentations of the parties' evidence and arguments. Whereas at the hearing, each side of the challenge was given 30 minutes to present their evidence and arguments. Whereas committee members reviewed the parties' written submissions, heard oral presentations from the parties' counsel and parliamentarian expert witnesses, and debated the merits of the challenge. Whereas the committee found no violation of the DNC's charter or of any other rule applicable to the election. Whereas the DNC Credentials Committee found no ongoing breach of any fundamental rights of DNC members. Now, therefore, the committee hereby resolves that the challenge be denied and Vice Chairs Malcolm Kenyatta and David Hogg retain their credentials as Vice Chairs and DNC members.
Thank you for that. And then so I see we have Ms. Davis who has her hand up and was first. And Ms. Davis, can you state which side you're speaking for, and can we get the clock on there in terms of, we have 20 minutes in terms of the committee to discuss this. So thank you very much, Ms. Davis.
Yes, thank you. I oppose this resolution. And I don't know if it's appropriate to ask questions, but I remember in the briefing that y'all were kind enough to provide for us, I attended the first one, and you said that the staff would not be presenting a resolution, but this resolution feels pretty well put together. And I was wondering if Ms. Pelosi drafted it or staff drafted it. I think that's just an important question to get out of the way. I in no way am suggesting that anyone intended this to be a problem and things to be out of whack, but the women were put at a disadvantage by the 2 baskets being added together, and that is a fundamental problem of not allowing gender parity. And so I think that to just say no problems, nothing to see here is not an appropriate response for this committee to take over something that is of this importance. This election was out of balance by combining the 2. Again, I don't feel like anybody was trying to make that happen, but that is what happened, and I think it's something we should address. And I think dismissing it does not address it. Thank you.
Thank you. Mr. Jacobs, you're up next.
Yes, I oppose this resolution as well. I agree with what Ms. Davis said completely. Look, I was there. It was getting late. It was, it was a long day. No one could have foreseen the consequences of a decision to have the voting take place that way. I certainly didn't at the time, and at that time, had I seen it, I would have made my voice heard. The fact is that, both sides have made great points using Robert's rules, using our own rules. I could go either way on those points because frankly, they're all good. And I think the presentations were good. But it boils down to this. Was this election fair, fair to the women candidates? And the answer is no. I mean, I can't see how it's fair. And if it's not fair, then the answer is we've got to do something about it. So I oppose this resolution, and I think we've got to find a different alternative.
Thank you, Mr. Jacobs. Mr. Catt?
Thank you, Mr. Chair. First of all, I'm very cognizant of the fact that the requested solution by the challenger would necessarily disenfranchise the 24 or so members who voted in good faith on February 1st and whose term on the DNC has since expired. It's pretty clear the challenger has not proven that the election violated DNC rules. The rules of the election gave discretion to the chair, period. DNC rules overrule Roberts. That should be the end of it. But even if we grant all the allegations made by the challenger, with Jane Kleb's election as ASDC chair, we must now elect 2 men to the last 2 vice chair positions or violate our own rules on gender parity. Section 3A3 of the DNC's rules of procedure state, pursuant to the charter, Article 3, Section 1E, except for the national chair, so excluding Ken Martin, candidates nominated to fill DNC officer vacancies that occur outside of the regularly scheduled elections of the president of the ASDC shall continue to ensure DNC officers are equally divided as practicable according to gender. We have Jason Ray and Chris Corge, Virginia McGregor, Raina Walters Morgan, Artie Blanco, Jane Kleb. The only way to make this balanced by gender, even if we agree with all the allegations proposed by the challenger, is by electing 2 men. There are only 2 men. There are no non-binary candidates left. The only way to do it is by electing 2 men. So even if we were to uphold it, we would end up with the same exact result. So I ask my fellow committee members to please join me in supporting this resolution. Thank you.
Thank you. Thank you, Mr. Klatt. Governor Walters?
Thank you very much, Mr. Chairman. I think I just want to say, first of all, echoing a bit of what Mr. Jacobs said, we're a party that believes in doing the right thing. We're a party that believes in fair elections. And this election in no way, shape, or form was fair. It could have been fair. It was unusual and not anticipated in any of the rules. December 12th, January 25th, the late night email that went out, it was never anticipated that there was going to be a male ballot, a male vote, and a all gender ballot combined. And so understandably, whoever put that together got confused and failed to, they decided we're going to save some time. We're going to put them both on the ballot and then we're going to have a vote. But the failure here that no chair can take responsibility for this. You can't give the chair the right to overcome this when the chair's not going to stand up there and say, we want the men, now that we're going to collapse the voting into one question, we're going to give the men twice as many votes as the women. The idea that David Hogg got 291 votes in his, 214 votes in losing to Malcolm Kenyatta in 512 votes, which should have been 411. The idea that he got 214 and that they count again in the all gender ballot, he had a 214 vote lead on the women before they ever started the counting is just not fair and not the right thing to do. And I agree. We've heard all this about points of order, but I tell you what, I'm going to take the guy that wrote the book as opposed to somebody that's a parliamentarian in Utah for 7 years. I'm going to take people who are expert in this field and who can, and even I can read the Robert's Rules of Order, have been in lots of meetings with them. I can see the continuing fact of this. Continuing effect, we declared somebody elected to the 3rd position that would have come in 5th had the ballots been counted properly. And so the mistake was made. What was done was fine, putting 2 ballots, 2 questions on there. It made it confusing, but we had 2 lines on the ballot. The mistake was made when they said When they didn't say, you must put the mail ballot and the male vote first and the all gender vote second. And that's where the train came off the tracks. And David Hogg got to count 214 votes twice. The men had access to 817 votes. The women had no chance of winning this election. This was a failed election. It should be redone. It's not that inconvenient. If we're a party of fair elections, and if we want to do the right thing, we have to stand up and make sure we do something to correct this.
Thank you. We got 8 minutes left. Ms. Lucas?
Yes, hi, thank you so much. I just want to say I agree very strongly with the words of Jay, Wendy, and David. I'm definitely against this resolution. And I just want to add one bit of information. I would feel this way regardless of where we were in terms of counting the head of the Association of State Democratic Party Chairs, but also Rules of Procedure 2.C.5 says, in the election of 3 remaining vice chairpersons, provision will be made to elect the appropriate number of persons of each gender to ensure that, with the exception of the national chairperson and the president of the Association of State Democratic Committees, the officers shall be as equally divided as practicable according to gender in accordance with Article 3, Section 1E of the Charter. So anyways, those are my comments. I am against this resolution for all the reasons that my colleagues have stated. And then I also think that anyone who is considering the gender parity issue of having already of the chair having appointed a female to the head of the State Association Democratic Party chairs, I don't think that's really applicable, it appears.
Thank you. Mr. Mallory?
Thank you very much, Mr. Chairman.
Which side? I mean, just in terms of opposition side, has 3 minutes.
I'm in opposition to the resolution that's been presented. I've listened to the experts on both sides of this issue. I am very aware of the mathematics problem that we have all discussed quite a bit at this point. And for me, it's very difficult to get past the math problem. I can say with certainty that our former chairman did not do anything to intentionally disenfranchise any of the candidates running for vice chair. However, the result has been just that. I don't see how, as the Democrat Party, the party of free and fair elections, we could be aware of a situation that has disenfranchised candidates for office within our organization, when we know good and well we would never stand for something similar if it happened at our local board of elections. It is for that reason and many others that I oppose this resolution. I yield.
Thank you. Mr. Valdez?
Thank you, Mr. Chair. I'll be speaking in favor of the resolution. First, I do want to acknowledge that I know when the ballots were cast and our Chair Harrison made the comments on how to vote. I mean, I will admit I was a little confused, but once he further explained what was going on, then it was very clear what we had to do. For me, it comes down to, and I think all of us here, I think all of us have been at thousands of Democratic Party meetings in our lifetime. For me, it comes down to, and as was brought up, if the time to object either would have been when the chair made his announcement on how the ballot was going to go, or even after the results were tallied. But no one said anything. No one of either of the candidates who were not successful did not say a thing. And for me, that's what is like the overwhelming part of me that says why this, that was the time to eject and we need to uphold the elections. There were some comments made a little earlier as we were debating here about that mistakes were made, this was an unfair election. And I wanted to actually dispute that. I think our elections were fair. It was clear what we were voting for, and I just want to dispute the fact and put on record that it was a fair election that we conducted. So speaking again in support of this resolution. Thank you.
Thank you, Mr. Valdez. Mr. Buckley?
Thank you. I'm in support of Christine's motion. I think that we all walked into that that room, believing, many of us did, that the process that she described, that we're all going to have 3 votes, and that we're able to divide that up, and it would proceed as a whole. And the fact that it's only being challenged the last 2 and not the entire process, I think that disenfranchises those of us who had to limit our votes and our voices in the first round. I believe that if we were to, that we should at least have a conversation whether or not all 3. That said, I don't think it has been proven that there was any clear rule broken or that there was any ill will or intent. I do believe that it's creating a precedent that we need to be very careful about, and that if there was clear evidence, if it was a clear shut case, absolutely. But with so many factors being gray, I find that it's very difficult to not support Christine's motion. And just finally, I want to say, folks, this is all a problem that New Hampshire's been complaining about for years. It's limiting the role of women in our party. That, 60 years ago when we put the role in saying that it has to be gender equity, sure, that was because when women weren't being elected. But in New Hampshire, we have an overabundance of phenomenal women, and they're held back because they have to. You're only allowed to have 50% of a delegation to the convention or to the DNC, and frankly, it should be no less than 50%. There shouldn't be a ceiling; it should be a floor. Thank you.
Thank you. Thank you, Mr. Buckley. Ms. Rawlings?
Yes, I am very much in support of Christine Pelosi resolution because of the diversity that was shown in this election. The rules of the DNC, I just can't see that the Robert rules would overrule the rules that we accepted from the DNC. And I know that women have been kind of neglected and not put in leadership roles in the past, but we have a great gender balance, diversity balance in this election. So I agree with this resolution.
Thank you. Do we have anyone else? I think we have 1:30 left for the opposition, and I'll have to check on the support side. Mr. Walters, you have 1:30.
Thank you very much, Mr. Chairman. Ray, I appreciate your points that you made, but let me just clarify that there's nothing wrong with the first ballot. The first ballot was all gender. We had 2 votes that resulted in the election of Artie Blanco. Everybody had 1 vote on the first ballot. They had 2 votes on the next. No confusion about that. The third ballot, however, in the interest of time, put 2 ballots together. We should have, in hindsight, said, let's do a male vote, and then let's do the all gender vote. But instead, we put them all together. That's fine. That's happened before. Normally, it's like male. In fact, the presentation on January 25th suggested that it was could be a man or a woman. But the problem here is that we then combined the vote. We had 2 questions and a single vote, and it was patently unfair. And it sets a precedent. It does, in fact, set a precedent that we will accept an election that structurally made it impossible for women to win an all-gender ballot. That's the precedent we're setting here, and that's what pains me to think about as we go forward into future elections. We need to defeat this and deal with a resolution that corrects this problem.
Thank you, Mr. Walters. Anyone else? Mr. Cap? And there's there's 4 minutes left for the support side, 30 seconds left for the other side.
Thank you, sir. When it comes to a parliamentarian who serves on the DNC, like Brad Townley, or a parliamentarian who's being paid for his testimony, I'm going to go with my fellow DNC member who understands DNC rules and who understands that DNC rules always take primacy over Roberts. DNC rules said that the DNC chair had discretion. Jamie had discretion. No one objected at the time. And even under Roberts, which specifically stated that under Roberts 2710, that the demand to split the question must be asserted before the question on adopting the series has actually been put to a vote. No one made that demand. Under Roberts, it's required for the chair to accept that, but no one made that demand before the vote was cast. This is a simple question at the end of the day. And then, as I stated before, if we agreed with all the allegations that the challenger is making today, we would only be able to vote for 2 men in order to ensure gender parity. Because of Jane Kleb's election as ASDC chair, we can't simply ignore that she was elected ASDC chair for convenience sake. She is the chair of ASDC. She is a vice chair of the DNC. We, excluding Ken Martin, per the rules, excluding Ken Martin, and if we vacated both David Hogg and Malcolm Kenyatta, we would have 2 men, Jason Ray and Chris Corge, only 2 men versus 4 women as officers of the DNC. We would only be able to vote for Malcolm Kenyatta and David Hogg. We would not be able to vote for any other women or any women for these 2, for the last vice chair, currently all gender position. Thank you.
So the opposition side, you got 12 seconds. So be fast, Ms. Lucas. Ready, go.
Okay, that is not true in terms of gender parity. We do not need to consider, even if that was a factor in people voting, which I'm not saying it should or should not be, but we do not need to consider the president of the ASDCA gender in gender parity considerations.
Okay,
It's
I
just,
think that's time. Thank you. Anyone of the proponent side left? Going once, going twice. You trying to raise your hand again, Michael? Okay, sorry, Mike. Go ahead.
Yeah, I'm sorry, Ms. Lucas. That's simply not what the rules say. It says, excluding the chair, candidates nominated to fill DNC officer vacancies that occur outside of regularly scheduled elections for ASDC president shall continue to ensure that DNC officers are as equally divided as practical according to gender. If it was the intent of the DNC and the RBC to exclude the ASDC chair's gender, we could have done that. The rules currently say except for the national chair. It could have said except for the national chair and president of the ASDC, but it doesn't. So we must consider the gender of the ASDC chair.
I'm sorry.
Thank you, Mr. Chair.
I'm gonna call time there. Thank you very much in that regard. The chair will now call for a vote of the resolution to dispose of the pending challenge. A vote in favor of the resolution means that you are in favor of denying the challenge. A vote against the resolution means you are not in favor of denying the challenge. Should the resolution fail, we will return to debate. I will now ask Helen to call the roll. When your name is called, you will be unmuted. You will be muted once your vote has been cast.
Be the first one to vote again?
When your name's called, if you would like to vote in favor of the resolution, please signify by saying yay. If you vote to object to the resolution, oppose the resolution, vote no. If you're holding any proxies when that person is called, your mic will be unmuted and you can verbally cast that vote. Production team, you can begin unmuting members. Helen, please call the roll.
Yes, Mr. Chair. Mr. Aguilar?
Yeah.
I'm sorry, sir. Is that a yes or a no?
Yes.
Thank you.
Yes, ma'am.
Mr. Buckley?
Yes.
Votes for. Ms. Davis?
No.
Votes against. Mr. Jacobs?
No.
Votes against. Mr. Cap?
Yes.
Votes for. Mr. Lee?
Yes.
Mr. Lee votes yes. Ms. Long Hong?
No.
Ms. Long Hong votes against. Ms. Lucas.
No.
Ms. Lucas votes against. Mr. Mallory.
No.
Mr. Mallory votes against. Mr. Middleton.
No.
Mr. Middleton votes against. Ms. Pelosi.
Yes.
Ms. Pelosi votes for. Ms. Penske's vote. Ms. Lucas? Ms. Lucas has the proxy for Carol Penske.
Against.
Ms. Penske votes against. Ms. Rollins?
Yes.
Ms. Rollins votes for. Mr. Ruiz, that proxy belongs with Ms. Davis.
No.
Ms. Ruiz votes against. Mr. Valdez.
Valdez votes aye.
Mr. Valdez votes for. Mr. Walters.
No.
Mr. Walters votes against. Chairs, Mr. Ramirez, do you wish to vote?
I vote aye.
Mr. Ramirez votes for. Ms. Solis?
Aye.
Ms. Solis votes for. Mr. Chairman, I have 9 for, 9 against.
I
I'm
did
sure
too.
someone else was tallying.
I did too. So that means we're up for further debate. Correct?
Under our rules, we entertain a new motion.
Yep, and I'm going to recognize Mr. Walters. Mr. Walters?
Thank you, Mr. Chairman. I have previously sent to you and the staff today about noon a alternate resolution in the event that the initial resolution failed. And I wonder if that's possible for you all to put up and to read through similarly.
Yeah, give us a second while I ask folks to put it up, and I would ask them to read through it again, just like we did the last one. Mr. Middleton, you got your hand up? Do we want to recognize Mr. Middleton?
I appreciate it, Mr. Chair. I have a question. I know we alluded to the DNC's parliamentarian, but we have not heard from the parliamentarian. And if appropriate, wanted to get her take on the timing and situation, if that is appropriate to ask her.
I mean, I think in terms of where we are right now, I mean, I think we're up for a new vote. I think it's more appropriate to move forward with the vote.
Okay.
I'm sorry. I think just, we've got a new about to be motion on the floor, and I'm sure a second. And
okay, thank you.
Wendy, can we, or no, why don't we get a second? We got a motion. Can we get a second? Yeah. Can you unmute?
Yes, I'd like to second the motion.
Yeah, sorry.
That-
I knew where you're going. Sorry. Yeah. So we got a motion and a second. Now, if we could, we can get it up for discussion. If we can get that. Yep. Thank you very much.
Great. Okay, I will read through this. This is a draft resolution submitted to the Credentials Committee by committee member Governor David Walters. In the matter of the credentials challenge, the challenge brought before the Credentials Committee, the Committee of the Democratic National Committee, the DNC, by Kaylin Free, the challenger, regarding the credentialing and elections of Malcolm Kenyatta and David Hogg as vice chairs of the DNC, the committee finds and recommends the following. Whereas on the third ballot of the DNC election held on February 1st, 2025, there were 2 males and 3 females running for the opportunity to fill the remaining 2 at-large vice chair position with a male-only vote and then an all-gender vote for the final at-large vice chair position. Whereas in order to save time, the DNC combined the 5 remaining candidates on 1 ballot with 2 votes, and the members were instructed that they must cast 1 vote for a male candidate and their second vote for an all-gender candidate. Whereas the voting instructions provided by the DNC unfortunately failed to make clear that the votes for a male position and the votes for an all-gender position should be separate and distinct, with the male vote on 1 line of the 2-line ballot and the all-gender vote on the 2nd line. Whereas as a result of not separating these 2 votes for 2 different positions, the challenger has demonstrated that the 2 men on the ballot, Malcolm Kenyatta and David Hogg, were allowed to compete for all 812.5 votes cast, while the 3 women were restricted to 411 votes of the 812.5 votes cast on the third ballot. Despite the bias in the voting pool, the votes for male and for all gender were combined, and both the men and women were required to meet the same majority win number of 205 votes. Because 2 men competed for double the number of votes as the women, it was mathematically impossible for any of the 3 women to reach the majority win number. Whereas the challenger has illustrated that of the 411 votes available for the all-gender election, 330.5 were cast for women, leaving 110.5 male votes cast in the all-gender election. The combined vote tally makes it impossible to determine the preference of these 110.5 votes for Kenyatta or Hogg, but what is clear is that if the all-gender count had been separate, Kenyatta and Hogg would have come in 4th and 5th place on the all-gender vote. Hogg instead was granted the all-gender position because all 214.5 votes cast in his losing effort to win the male vote were counted again in the all-gender vote, giving Hogg a 214.5 vote head start on the women on the all-gender ballot. Whereas the challenger established through statistical and mathematical analysis that the balloting and execution of the 2nd and 3rd vice chair at-large positions created a systemic disadvantage for the female candidates, undermining the principle of gender equity as required by DNC rules. Whereas the challenger proved that the standard parliamentary procedures were not followed during the 3rd ballot elections and tallying of votes. Whereas the challengers demonstrated that the filing of the challenge was made in a timely manner as outlined in Robert's Rules of Order newly revised 12th edition, which states that exceptions to the requirement that a point of order must be made promptly at the time of the breach arise in connection with breaches that are of a continuing nature, whereby the action taken in violation of the rules is null and void. Several instances of such continuing breaches are provided, including when any action has been taken in violation of a fundamental principle of parliamentary law, and when any action has been taken in violation of a rule protecting a basic right of an individual member. Whereas several DNC members also challenged the election in support of the challenger, attesting that they were also disenfranchised during the election by being prevented from selecting the last at-large vice chair position. Whereas the challenger demonstrated that the combining of the votes for the male position and the votes for the all-gender position created an overwhelming advantage to male candidates over female candidates, appears to violate 2 provisions of the Charter. Article 1, Section 4 states that the Democratic Party shall establish standards and rules of procedure to afford all members of the Democratic Party full, timely, and equal opportunities to participate in decisions concerning the selection of candidates, the formulation of policy, and the conduct of other party affairs without prejudice on the basis of sex. Article 8, Section 2 states discrimination in the conduct of Democratic Party affairs on the basis of sex is prohibited to the end that the Democratic Party at all levels be an open party. Therefore, be it resolved that the Credentials Committee of the DNC of the Democratic National Committee hereby determines that the vice chair positions held by Malcolm Kenyatta and David Hogg are vacant due to violations of the DNC Charter, bylaws, and parliamentary procedures. Be it further resolved that the committee recommends that the DNC conduct two new and separate elections to fill the resulting vacancies, the first to elect a male vice chair and the second to elect a vice chair of any gender. Be it further resolved that the committee recommends that only the candidates who were improperly displaced or disadvantaged in the original election be eligible to stand in the new election. Be it finally resolved that while the committee affirms the seriousness of the procedural violations, it also acknowledges that these errors were not the result of intentional misconduct or malice.
Right on, thank you. So again, we've got, I got to get back up to the number. I think it's 30 minutes aside, right? Do we have folks who want to advocate in favor or against this motion or this resolution? Sorry. Mr. Jacobs.
Yes. Once again, I want to speak in favor of this resolution. I think it really, I think it resolves the issue in a fair way. As I said before, unintentionally, most certainly, and I was a party to this. I was in the room. I voted. I supported what was happening at that moment. I had no idea that the mathematical result would have been what it is. I want to make a point on two other issues that were made earlier, that I think one in error and one a bit of confusion. There was the question of disenfranchising members who voted in the last election who were no longer members of the DNC, and that this was an issue of concern to some people. I view it differently, and I don't view the individual as the one who is disenfranchised or who owns the vote here. I think I represent, I'm the state chair of New York, and I am on the DNC by virtue of that. It is my seat and my position that does not get disenfranchised by having a new vote. I, as an individual, may move on and someone else may fill my seat. I wouldn't want that seat in New York as being disenfranchised by not being able to vote, but it will vote no matter who's in the seat. The other thing I would say to you is that I looked up and I got information on the rules of procedure, and I think they were inaccurately referenced before. As far as I have, the rules of procedure, DNC 2C5 say, quote, in the election of the 3 remaining vice chairpersons, provision will be made to elect the appropriate number of persons of each gender to ensure that, with the exception of the national chairperson and the president of the Association of State Democratic Committees, ASDC, the offices shall be as equally divided as practicable according to gender in accordance with Article 3, Section 1E of the Charter. So my question is, let's assume in the last round, in fact, a male and a female had been elected. What would we then be doing, and what would have happened given that a female was elected the following day as president of the ASDC? This does not disqualify a revote and the potential of a female being elected in the next round on a revote. Thank you.
Thank you. Mr. Mallory?
Thank you. And Jay, I just want to drill down a bit. I'm in support of this resolution. And I want to drill down on this issue of the head of the ASDC. I don't get a vote for that individual. So that does not come into play when we're talking about the gender balance of the officers of the DNC. Whatever happens at the ASDC is what happens there, and it is subsequent to all decisions made by the larger body. I really like this resolution because it is obviously very well structured, but it really speaks to the issue. It makes it clear what the problem was, and I believe that it makes clear what the remedy should be. You know, sometimes when something is broken, you break your leg. It's a terrible thing. It's painful. And sometimes when you go to the hospital and they have to reset that leg, that process is painful too. But it is a part of the recovery of the initial incident. So we have, I think, a responsibility here to act. We have been given a lot of information by a lot of people, and I will say it doesn't bother me that one of the experts who testified today is paid for their expertise. That is something that I think people who are expert in lots of fields do on a daily basis. So that does not inherently disqualify their comments to us as a body. So I stand in support of this resolution, and I hope that we can get it passed. Thank you.
Oops. Thank you, sir. Mr. Middleton?
Is now the right time to ask Helen to comment?
In what regard? I mean, I don't think it's fair to put her in the middle of the discussion in terms of the discussion. I do think it would be in terms of for all of us to keep in mind kind of the timing on when the election would be if this resolution was to pass. I don't think it's fair to stick Helen in the middle of a decision that's already been made. We made the decision that the last one didn't pass, and then this one is up for discussion. So I think we should keep it to the discussion of this resolution.
Okay, Mr. Chair.
All right. Thank you, Clay. Ms. Pelosi?
Yeah, I have a couple of questions. One, yes, I did write the last resolution. Answer to that question. I was writing it during the meeting. In fact, rewriting it during the meeting. I would, I guess, ask Mr. Walters, Governor Walters, for some friendly amendments. I have two fundamentally, I don't think that my rights as a DNC member were violated. I'm not sure what Mr. Jacobs meant by saying the seat from California's, if you voted last time, that the seat from California's right was vacated, and then there's a new person in that seat. You know, that language doesn't sit right with me. If you want a new election, I have three fundamental questions. One, is it the same people who voted before? Yes or no? Two, if it's the new DNC, is it the same 5 candidates who are voting, who are eligible, and only those 5 candidates? And number 3, would you put in some sort of acceleration language akin to the fact that we would have this vote conducted by mail as we had done in 2011, 2017, and so forth, to cure other vacancies? So those 3: number 1, who gets to vote; number 2, who gets to run; and number 3, how quickly would we have this vote by mail amongst those candidates running and those voters casting ballots?
Mr. Chairman, may I respond to the question?
Oh, yeah. I think.
I put it this way: would you accept a friendly amendment that would say, that would describe?
You're putting me in an awkward position, but yeah. I mean, Mr. Walters, you have any comments?
Yeah, Christine, are you referring to the whereas it says several DNC members also challenged the election and were disenfranchised?
No, I'm saying if you're saying that.
I'll answer the other 2
everybody
questions.
who voted was disenfranchised, right? That presumably everyone, then how do we cure the 22 people who were gone? Are you suggesting that the new DNC vote or that the February 1st DNC vote?
Yeah, the mechanics of this, I think, and frankly, I'd sort of leave that to the leadership, but the mechanics, I think, would require the new DNC voting. I've assumed that this would happen at the next regular meeting in August of the DNC. But the DNC, for your suggestion, I think the language here doesn't say that. We could say as soon as practicable, and leave it again to the leadership if they want to run a virtual election among the DNC members, or if they want to wait till the August meeting to do this. I'm happy to go either way. And what your suggestion is in that regards is just as soon as practical.
Okay, and then my last question was, are you suggesting that this committee find that only these 5 candidates?
Yes, I think it would be unfair to the 5 candidates to basically say, okay, you did all that campaigning, you worked your butt off, you got to the end of the game. Right. There was a voting instruction. We're sorry about that. We didn't separate the count. Apologies. We're going to do it again. We're going to separate these 2 votes and do it properly and not be rushed in the late hours of the night. And so yeah, I think the language here is intended to say that the candidates who were improperly displaced or disadvantaged. I'm happy to make that more explicit and say that the only candidates would be the 5 candidates on the last ballot.
Okay, so that would be your second to last resolved,
Right.
right? That it's
Right.
only those 5. And would you also add the committee should consider recommending that the DNC allow the chair to conduct an email election to resolve this as soon as is practicable? As we have done in the past.
I'm happy to do that. I mean, I think that would be, do we have language as soon as practicable in here? I'm not seeing it.
No, I think we need to put that in there in the further resolved.
And would it be all right if maybe we also asked the attorney for the DNC in terms of if the intent is to make it compliant with the charter and stuff, is there anything else? I mean, maybe I'm out of school, but to ask Andy if there's anything else that if your intent is to allow for as soon as practical, is there anything else we need to cross our I's and dot our T's on to make sure that that's workable?
Yes, so on that piece, if the interest of the committee is to allow for the DNC to vote earlier than the August meeting, including by a mail or email ballot, the rules of procedure that were adopted for this election do contemplate a meeting. So I would recommend that we be more explicit that the committee is recommending to the DNC that when it adopts the committee's report, that it allow the chair to hold a mail or email ballot if that is what the committee would like to do.
So would we say as soon as practical, whether in person or virtual?
Sorry, where is the practicable language?
Well, I'm adding it to the second, be it further resolved. So you'd say after of any gender, as soon as practicable, whether in person or by email or by it may not be email, but I just say by
electronically.
Or electronically. Yeah.
That covers both.
Yeah.
And then I also recommended some language on the next be it further resolved to clarify that the intent of Mr. Walters is for the 5 candidates who are eligible for the 3rd ballot on February 1st to be eligible for the new balloting.
Only those 5.
Only those 5, yes. Only the candidates who are eligible.
And then finally, does this cure so that we're not here again over the summer or whatever? Are we saying explicitly one ballot or one series of ballots per position?
Yes, I think having experienced this complexity, I think running a male and an all gender position on the same ballot and trying to get people to put it on the right lines, et cetera, we're not going to be as pressed for time, I hope. And so I think it says here on the first to elect a male vice chair and the second to elect a vice chair of any gender. So the
but I would say ballot series because it may not be one ballot. Remember, Artie was 2.
Right. So on 2 separate ballots, we could insert that
ballot series because it's a ballot. It's a you're calling it a continuation of the election, right? So it would be a series of ballots to elect the male vice chair and then a series of ballots to elect the vice chair of any gender.
Right, because it could be that any gender might have a second round.
Correct.
The male ballot's going to be a single vote.
Unless a whole bunch of people abstain, yeah.
A single majority.
Right. Or don't do something.
Yeah.
That's right. So, we don't know.
So I'm happy with that. I'm just not sure. Andy, are you following exactly where we should make that change?
No, can you please repeat it?
2 new separate elections to fill the resulting vacancies using a series of ballots. That's not clear. To conduct new and separate elections to fill the vacancies. The first ballot to elect a male and the second ballot or series of ballots to elect a vice chair of any gender. Does that get it?
Makes sense.
The first ballot, because we're only going to have 2 candidates.
So don't say election. You would just say, because remember, the expert, Dr. Siebold said it was an incomplete election. We're not starting a new election.
That was my question, because Ms. Free's expert had said that this would be an incomplete election. Do we want to also edit these resolved to clarify that this is not leading to a vacancy? We are moving to balloting to complete the election.
Yeah, I
Yes.
think are vacant due to violations, and therefore the elections are incomplete.
I wouldn't declare a vacancy. I think legally that means something else. I would just say our
Determines that the vice chair positions held are I think you've got to say they're were incomplete.
yes, are incomplete.
Are incomplete.
Yeah. Because basically what you're doing is you're doing a point of order. Yes, it's a few months later, but that's effectively what you're doing.
Right.
So had we been doing that day, you would say, oh, we better do a revote, one series at a time per position.
Right. Andy, did you get that? So I'm thinking, and the last full sentence on therefore be it resolved, after it says and David Hogg, instead of the words are vacant, you'd say are incomplete.
Yes, that is in there.
And then just in terms of,
I'm sorry. I'm sorry.
I know. I was just
Ryan,
going to say procedurally, if you're done right, if you're done writing, I'm trying to get too far ahead of you. If you're still writing, I apologize.
Yeah, Andy, I'm just thinking to make that sentence read clearer, you would say the committee of the Democratic hereby determines that the elections of the vice chair positions held by are incomplete due to violations. So you'd put in the second full line of the first be it therefore resolved in front of the vice chair positions, you'd just say the elections for.
Yep. We right now have it as that the Credentials Committee of the Democratic National Committee hereby determines that the elections for the vice chair positions held by Malcolm Kenyatta and David Hogg are incomplete due to violations of the DNC charter, bylaws, and parliamentary procedures.
Do we want to refer to it as the positions that are held, or just that the election is incomplete? Because if the election's incomplete, are they held?
The positions are held until the full DNC votes on this resolution. So the positions will be held by Vice Chair Kenyatta and Hogg until during this pendency of this challenge.
Right. That's right.
Moving on to the next one, be it further resolved.
Yeah.
Oh, sorry.
I'm just going to say, Wendy, if you give me the grace that we could like write this until we get there, because I'm trying. I think Wendy has a question. Do you have something, Jermaine? Okay. Well,
sorry.
Why don't we go ahead and unmute Wendy? Please.
Sorry,
No. I'm just trying to herd to a finish line.
Yes, no, I just got myself a little confused there. So if this resolution, which we're perfecting right now, passes, is there another vote that has to happen in a larger body before it's enacted? Or does our action today have the weight of this decision? Is my question clear? Because we're envisioning having some sort of email or mail vote in between before we get to August.
Yeah, I think functionally it would be to have the vote and stuff, and then it gets ratified by the full DNC. Is that right, Andy? And then it's not effective until it's fully ratified by the full DNC?
The second step of any credentials challenge is always that the committee's resolution is then referred to the full DNC membership to either reject or accept your report. Okay. At that point, this resolution will be fully adopted by the DNC, and we would then move on to, if this resolution is adopted, a vote.
Yeah. So Andy said it better than I understood it. So sorry.
So it seems that, am I understanding, Ms. Pelosi, that you would want us electronically or by mail before August have a vote that says, yes, we accept this resolution, and then here's the ballot. Yeah. Is that what you were envisioning? Because that wasn't clear to me.
Okay, here's what I would envision. First of all, I would take off in the first resolved. You don't need the violation of charter and bylaws piece. because we're already saying we're continuing the election. So we want to presume that we're having a correct election. So I would remove that part. Then what I would do is direct that this report be sent to the full committee for ratification and for adoption, and to the leadership, and upon support for the leadership to conduct a new election as soon as is practical, either in person or electronically. And that, I think, Wendy, gets to your question, which is, first you send it out to everybody and they adopt the report just like they do the credentials report at the beginning before we start voting for things. And then we would actually call a meeting of some kind, an electronic meeting or the Zoom, but also have electronic ballots, whatever it is, they would come up with an election. And I think,
Yeah, Christine, I'm happy to drop that language at the end of that, therefore be it resolved. We've made those points above in the whereas. So Andy, just strike as a friendly amendment due to violations of DNC charter bylaws and parliamentary procedures.
Okay. Yeah, I mean, I think.
I was just gonna say, are we good there, or is there?
I think so.
Because if we're at a place where, Andy, you have any questions or any clarifications just based upon what the intent of the resolution is?
Yep, we can do that.
No, I just mean, so do you feel good about that? It covers what Christine and Governor Walters talked about in terms of the intent behind it? Is there going to be any limiting factors by the charter or anything else we need to address within this that would get us to a finish line that lines up with what they've talked about?
The biggest piece here will be that since the rules of procedure for the election, which we want to adhere to as quickly as, or as closely as possible, do contemplate a meeting, ensuring that the full DNC membership, when they adopt your report, provides that flexibility that we just discussed to do this vote in person or electronically, including by mail or email ballot. Once the committee adopts this report, we would ask that they adopt the report to grant the challenge that is Mr. Walters' resolution, and then also approve that update to the rules of procedure. This will be
a multi-step.
It will be a multiple vote process to the membership if we do end up doing this before the August meeting.
Okay.
That the resolution that as written right now does allow for that.
Okay. Well, if it covers the bases, assuming that Christine and Governor Walters are good with it, I was just going to ask to confirm without objection that nobody has any objection to the inclusion of this, or otherwise I think we gotta vote on it. But I think if we just say, so long as nobody has an objection to this discussion here and modifications, that this is going to be what we ultimately end up voting on.
Yeah, I think she offered it as a friendly amendment, and I accept that.
Thank you. Yes, it's a friendly amendment. Thank you, Governor, for accepting all of that.
Helen, did I do that correctly in terms of the parliamentary side of it?
What you've asked the members to do is to adopt the amendment language they've been looking at as it was changed without an additional vote. They're doing it without any objection. So they will be incorporating the purple language that you can see on the screen if there is no objection to it.
And Mr. Mallory has his hand up, and do you have a comment or an objection or something?
No, Mr. Chairman, I was just going to add in, I would simply state without objection, the additions will be agreed to. Hearing no objection, the additions are agreed to as a procedural matter.
There you go. Thank you, sir. Thank you. Thank you. Well, I mean, I think we ate up a lot of time there, but do we have any comments any additional comments in support or opposition? Mr. Klatt? Yes, sir.
Thank you, Mr. Chairman. I wanted to respond to what the chairman from New York stated. I think the difference is that the ASDC president has now been elected. A revote, as he described, and as is being described in this new resolution, is occurring now with current knowledge, with current members, necessarily disenfranchising over 24 DNC members who voted in February but who are no longer in the DNC. I think that's a fact that we're not discussing, how we're disenfranchising 24 people who voted in good faith back in February. That's all that I have right now.
Thank you. Thank you. Any other comments? All right, then I think we're going to be in the position to move to a roll call vote. Oh. At this time, we will consider. Here, let me get there. A resolution has been offered and seconded, and if okay, a resolution has been offered and seconded. We already displayed it on screen. We already did the discussion. Okay, I will now call for a vote of the resolution to dispose of this pending challenge. A vote in favor of the resolution means that you are voting in favor of accepting the challenge, supporting the challenge. A vote against the resolution means you are not in favor, one more time, let me fix this a little bit, sorry. A vote in favor of the resolution means that you are voting in favor of supporting the new ballot, the new ballot challenge, in support of the new resolution. A vote against the resolution means you are not supporting the challenge. Should the resolution fail, we will return to debate. I will now ask Helen to call the roll. When your name is called, you will be unmuted. You will be muted once your vote has been cast. When your name is called, if you would like to vote in favor of the resolution, continuing the election, please vote by saying A. If you oppose the resolution, please vote by saying no. If you're holding any proxies, when the person is called, your mic will be unmuted and you can verbally cast their vote. Production team, you may begin unmuting members. Helen, please call the roll.
Thank you, sir. Mr. Aguilar?
Aye.
Votes for. Mr. Buckley?
Sure.
Votes for. Ms. Davis?
Aye.
Votes for. Mr. Jacobs?
Aye.
Votes for. Mr. Cap? Mr. Cap needs to be unmuted.
I vote no.
Mr. Cap votes against. Mr. Lee?
Mr. Lee votes aye.
Mr. Lee votes for. Ms. Leong Hong?
Aye.
Ms. Leong Hong votes for. Ms. Lucas?
Aye.
Ms. Lucas votes for. Mr. Mallory? Mr. Mallory, there we go.
Yes. Yes.
Mr. Mallory votes for. Mr. Middleton?
Aye.
Mr. Middleton votes for. Ms. Pelosi?
Aye.
Ms. Pelosi votes for. Ms. Penske? That's Ms. Lucas.
Aye.
Votes for. Ms. Rollins?
I sustain.
Ms. Rollins abstains. Ms. Ruiz? That's Ms. Davis.
Aye.
Votes aye. Mr. Valdez.
Valdez votes no.
Mr. Valdez votes against. Mr. Walters.
Aye.
Mr. Walters votes aye. Mr. Chairman, Mr. Ramirez, do you care to vote this time?
Not this time.
Mr. Ramirez abstains. Ms. Solis?
Abstain.
Ms. Solis abstains.
Motion passed.
You have 13 for, 2 against, and
I just unmuted everyone.
Unless it's a tie.
and 3 abstentions.
Okay, thank you very much, Helen. Thank you all to other Credentials Committee members for your thoughtful attention and consideration of this matter. I appreciate your commitment to this committee and our party. I know sometimes we have some bumpy discussions and the like, but we're all one family. I appreciate everybody's voice, and I hope everybody felt like they had an appropriate opportunity to be heard and voice their concerns and work through this process. I also want to thank the challengers for their work in partnership with this committee. I know this issue has taken a significant amount of time and effort for both sets of parties. And I also know that committing to something as arduous as Credentials Challenge is done through a love of the party. I appreciate all parties' commitment to the Democratic Party, and I'm appreciative of all of your efforts. The recommendation of the Credentials Committee on how this challenge should be resolved will be submitted to the full DNC as part of the report to the committee. Thank you again for the DNC staff, our parliamentarian, our council, and our technical support team. And thank you to all of you for your service and commitment to our party. We have completed our business. As such, without objection, I'm going to adjourn this meeting. So, well, maybe not. Maybe I can stop my adjournment if you want to say something, Mr. Walters. I'm sorry. Go ahead.
And Hilda Solis for your leadership and the briefings that you had in advance of this, the even-handed nature that you all approached this was in the best values of the Democratic Party. So thank you so much.
Thank you, Governor.
Yes,
thank you,
Governor.
Ryan. Thank you, everyone, too.
Yes, thanks, everybody.
And to the committee staff, thank you.
Amen, amen. And have a wonderful rest of your evening. And thank you all for your hard work and your commitment and love for our party. So I'm sure we'll talk again soon. So have a good evening. Thank you all. Goodbye.
Thank you.